Hello, everyone, and welcome to another episode of Hangouts and Headlines. Unfortunately, like so many of the other entries in Hangouts and Headlines on this particular topic, we have bitten off more than we can chew today, so we're going to have to cut the Hangouts section of our video a little bit short, and you're going to have to bear with me, if you will, as we go through these many topics to potentially take breaks, answer questions, and have conversations separate from going through those documents in order to make it to the end of this video. But I'm glad that you're all here with me today. I hope you are excited about talking about not just the Hollywood Reporter's package of articles on Blake Lively versus Justin Baldoni, but also Ms. Lively and her team's amended complaint today. If we can get through all of that in less than 4 hours, then we're going to have a lot of fun talking about a number of topics on a very popular and controversial set of events. I can talk, really. I'm glad that you've tuned in to see me pause in the middle of my introduction. I really appreciate it. But let's get to it before I just start pausing entirely. All right, so this is the cover of the Hollywood Reporter's set of articles that they put out on our favorite public relations war / legal battle in Hangouts and Headlines. And that is, of course, Blake versus Baldoni. And as you can see, it is an artistic rendering of this particular legal challenge and appears to be a reference to David and Goliath from the Bible. Now, interestingly enough, I did note when I saw this for the first time that the person that appears to be framed as David, the underdog slaying the mighty giant Goliath, is Blake Lively. And I do think that some people looking at this particular image might say to themselves, well, that's interesting. Usually when I think of this particular story as a Depp v. Heard, it isn't Justin Baldoni that is taking the Johnny Depp spot there. He's not the A-lister. He's not the one with the power in Hollywood. So why would you frame this as Blake Lively as David? But as we will see in the articles that they put in their magazine, one of the framing devices here is not just that religion plays an important role, which is how this winds up being a religious image, but also that both sides frame themselves as David and David versus Goliath. And I suspect that everyone watching this video or otherwise in the comments right now or watching it after the fact has their own feelings on just who is David and who is Goliath in this particular argument. So, with that as background, this is the cover image that caused so much controversy just from existing, as we will see in the Us Weekly article describing Blake Lively's response as slamming the sexist illustration depicting her and Justin Baldoni at war as offensive. Now, I'm not sure it's sexist so much as it's just a woman and a man at the cover of the magazine, but I will leave that for your judgment. This reporting says the Hollywood Reporter should be ashamed of itself. A spokesperson for the actress, Blake Lively, told Us Weekly in a statement shared on Saturday, February 22nd. The framing in this picture is outrageously insulting, as it plays into every sexist trope about women who dare file a workplace complaint, turning them into the aggressor and suggesting they deserve the retaliation that comes their way, the statement continued. In addition, the story is extremely offensive as it incredibly seems to explain away documented examples of sexual harassment and retaliation by calling them cultural misunderstandings. Now, that's our first kind of hook. We're going to have to dive into those articles to discuss exactly what it is the Hollywood Reporter said about this whole thing. And I think it's more complicated than the statement. That's not a surprise. As a spokesperson for one side in a legal battle, they're going to frame things as much as possible towards their client. That's what PR does. Importantly, it's to understand this entire story. That is what PR does. And PR is a part of this story because the PR individuals themselves have been sued in various configurations by both parties. And that's one of the things we'll see the Hollywood Reporter pick up on as a potential problem for public relations in Hollywood in general. The publication's most recent issue, including the now controversial cover depicting Lively, 37, slingshotting a cell phone at Baldoni, 41, as he ran away from her, clutching a copy of Colleen Hoover's book, It Ends With Us, from which their 2024 film was adapted. Baldoni also appears to hold a slingshot. And I highlighted that sentence because if you're familiar with any kind of AI writing anything, if you've talked to ChatGPT or Gemini or anything else in the AI space, this is the kind of nakedly obvious additional statement when asked to describe an image that I see a lot in AI. I'm not accusing Us Weekly of using AI to describe the image. It seems like a silly use of AI for this purpose, but it does have that same kind of writing mentality. And I do wonder, as part of the AI discussion, whether or not how AI actually outputs and interacts with us is going to be influencing the way we write and think about things in the future. And so I did want to note that because that's what I thought when I saw this paragraph, and I thought you guys might be interested in that. Now, this is the picture we were just looking at. Justin Baldoni here in the front. He does, admittedly, as the AI-like sentence says, seem to have a slingshot of his own, but he is not otherwise firing with it. That is Blake Lively firing at him with a cell phone or a very small iPad, always hard to tell. The cover is meant to depict the biblical story of David and Goliath, in which a young boy overcomes all odds with just a simple slingshot and a rock to defeat a giant. In the background, and we can't see this from that cover image, but we will see it in just a minute, Lively's husband, Ryan Reynolds, is depicted as his Deadpool character, Nicepool, who is rumored to be a depiction of Baldoni meant to mock the director. Baldoni's lawyer, Brian Friedman, is also depicted in the cover, standing behind Baldoni and opposite Reynolds' Nicepool with his hands on his hips. Again, a kind of nakedly obvious description of what is depicted in this image. Does sound like AI to me. The audacity to turn this whole case into a joke is alarming. I stand with Blake Lively because I believe her. I don't care if people say she's not a perfect victim or whatever. It really doesn't matter. One person wrote via X, predators should be punished. And this is the kind of article that we don't talk about too often in Hangouts and Headlines because it's basically sourced from things like Twitter posts, that's X now, Twitter to you and me from before Elon Musk's takeover. And they do this a couple of times where they say, hey, look, people are looking at this and backing up Blake Lively in her upsettedness at this image. I'm sure they are. I'm sure there are also X posters that are saying this is the most badass thing ever, and it just depicts what is exactly happening here. Or folks that are just really big fans of David and Goliath saying, I've never seen the story in this particular image. Incredibly inappropriate, another posted. You have a responsibility as a publication, but time and time again, yours has trivialized sexual harassment and assault, among other horrible things. And we see this a lot in this particular story. It is important as we discuss it, and we will in more detail when we get to the amended complaint, that we note that even Blake Lively, at the most positive, complete reading of her allegations, does not allege an assault. She gets close when she talks about intimacy on set being essentially improvised, but even that is not framed as an assault or a battery or anything like it. You'll also see PR people and others reporting on this story use the term sexual assault or worse in describing the events as depicted by Blake Lively or others, but that is not what is alleged here. What is alleged is sexual harassment, and more specifically, hostile workplace sexual harassment, which is involving essentially an abusive, pervasive sexuality on set that makes it difficult to perform work as it should be done in a work setting. Lively named Baldoni, 41, in a December 2024 lawsuit claiming that he sexually harassed her and allegedly fostered a hostile work environment on the set of It Ends With Us. She amended her complaint earlier this month, also detailing the emotional impact of the legal fallout. The emotional impact on Ms. Lively has been extreme, not only affecting her, but her family, including her husband and 4 children, her husband being Ryan Reynolds, Deadpool. Court docs obtained by Us read, there are days when she has struggled to get out of bed, and she frequently chooses not to venture outside in public. Our clients have been transparent in providing receipts, real-time documents, and video showing a completely different story than what has been manipulated and cherry-picked to the media, Baldoni's lawyer Friedman said in a statement to Us on Wednesday, February 19th. Our clients have taken this matter and these issues very seriously, notwithstanding the jokes made publicly by the plaintiff and her husband. And on this point, I did want to raise that others have mentioned on social media and elsewhere that Ryan Reynolds and Blake Lively can be seen at the Saturday Night Live 50th anniversary, and there's a video of this, where Ryan Reynolds is making light of this entire legal situation by saying, everything's fine with him, why, what have you heard, etc. I am not, in this video or this video series, going to dive too deeply into the various pieces of evidentiary ephemera that you will see on social media. I think there are people that are better at that. There are detective-like folks that are looking at those kinds of things, and there are a lot of lawyers in this space, even on YouTube, that are also discussing that with more minute detail. You can check those out. I recommend Legal Bites. I recommend Emily D. Baker. I recommend Ian Runkle and Rob at Law and Lumber when they get on a Friday Night Frenzy with This Is the Topic, if you're interested in those particular points. But I'm not going to be doing that here, primarily because this is a media-focused show, and because we have enough to read through from the media and the legal documents to take up more than the time that we have. So we're not going to be going into all the details there, but we will pick out little instances where I know that there are discussions being had, like the Saturday Night Live appearance, which I do think speaks against the notion that Lively and Reynolds are deeply emotionally affected. But I would also caution people to say, well, they clearly aren't because they made this one appearance on Saturday Night Live. Sometimes folks deal with emotional trauma with humor. Sometimes, even if they are traumatized, they can get excited or ready to go out on one specific night, and we can't just assume that they aren't damaged or otherwise affected by the events that are taking place in their lives because they managed to get that level of strength up. Now, I know people are probably in the comments already commenting that that's an awfully generous or naive way to look at that particular appearance. I tend to lean towards the folks that say it suggests that they are not as distressed as they are putting forth in their legal documents. But I just want to mention that it is not a smoking gun. It is not a silver bullet to say that they clearly aren't distressed just because they made a single one-line joke on Saturday Night Live. Okay, that's the Us Weekly article. Not a lot to go on, but it's just important to set the tone here for Blake Lively is upset about this particular cover. We're going to take a look at it more completely in just a moment. I also wanted to flag this People article as one of those points where folks are discussing things on social media, this time related to the controversy around Justin Baldoni's being dropped by his agency. And in this particular People article, and there's a lot of articles towards this particular story, but this was linked to me by Against the Tide, who is in the chat right now, helpfully modding out these conversations, hopefully helping everybody have good, reasonable minds can differ conversations in our chat. She linked this story to me because it does highlight one of the issues that Team Lively has here, which is to say, Justin Baldoni says Blake Lively and Ryan Reynolds, especially Ryan Reynolds on the red carpet to Deadpool and Wolverine, essentially required his agency, which was shared with Justin Baldoni at the time, to drop Justin Baldoni. And so the agent coming out and saying, I am ride or die with Reynolds and Lively, is an important part of this story. The talent agency executive allegedly responsible for firing Justin Baldoni from its roster is speaking out and praising clients Blake Lively and Ryan Reynolds. I'm not sure you need an allegedly there based on what's in this article, but fair enough, people. Your lawyers are on task. In a live taping for the Freakonomics podcast with host Stephen Dubner, Ari Emanuel, the chief executive of WME's parent company Endeavor, spoke of his personal relationship with Lively, 37, and Reynolds, 48, amid the actress's ongoing It Ends With Us legal battle with Baldoni, 41. And I keep saying these ages, and it strikes me as a weird way to write these articles. I know these articles are written with those ages next to people's names. I don't really understand why. I'm not sure what role the age plays in understanding this story any better. I'm sure there's a reason for it from a commercial perspective, but it is odd to me to read them out loud that way. Baldoni's former talent agency WME dropped the Jane the Virgin star, that's Justin Baldoni to you and me, on December 21st. The same day, it came to light that Lively sued him for sexual harassment. That's wrong. She doesn't sue until the 31st, but that's fine, people. And accused him of running a smear campaign against her. Emanuel shared that he has known Lively and Reynolds for over a decade and called them really incredible people. They've never had any bad mojo out there or treated people badly, Emanuel said. He added, if all that Lively's lawsuit alleges, including Baldoni sexually harassing her on set and fueling a retaliatory public smear campaign to destroy her reputation, is true, then those involved are really bad people. In fact, you can hear me say a very similar sentiment when we read through the original complaint in the first video of this series, which is to say, hey, look, what is being described in this document does sound like a hostile work environment, does sound like a potential sexual harassment issue, and we want the law to prevent those things from happening. But there are two sides to every story, and that's why we've been going through all these documents and trying to judge for ourselves exactly where the truth lies in between these various versions of events. But I look at this as a lawyer and say, this is a media-trained, legally trained type person who does put forth, at least as People describes it here, that all he's responding to is if the complaint and lawsuit that is based on that complaint are true, then they're very bad people that committed these crimes. They're not crimes really, but they committed these law-breaking actions that harmed my client, Blake Lively. So even though I've seen this reported as the agent himself is creating problems and saying that he fired them because he just believes Lively and Reynolds, there's some truth to that, but it's not entirely true because we can understand why somebody that is in commercial business doesn't want to wait for a lawsuit or settlement to finish these things off. We don't want to be associated with people that we think are bad or that could hurt our business, and that's why I dropped him. It isn't necessarily because Ryan Reynolds asked me to on the red carpet, which is a difference from what Justin Baldoni and his team have argued in their lawsuit. So both sides have weaknesses here, and we're going to see Blake Lively's weaknesses in her amended complaint very shortly. But Justin Baldoni has weaknesses in his case as well. I've discussed it in this video series, but I don't think a lot of the actual legal claims that he makes in his case have a high likelihood of victory at the end of the day. That's one of the reasons I think this is all going to get settled at the end. But this is a public relations fight more than it's a legal battle, which is why it's in Hangouts and Headlines and not virtual legality. Speaking of Lively and Reynolds, he said, "These are good people who have been in business for decades and have never had any bad press about them." Ryan Reynolds, are you sure? I think he's had some bad press. And all the people they've worked with like them. That's fine. Sure. Later, when speaking of Baldoni, Emanuel confirmed, "I fired him." See, that's why you don't need the allegedly at the front, people. Adding, "I am ride or die." In a statement to People, Baldoni's lawyer, Brian Friedman, said perhaps Ari's perspective would be different if they had ever met in the half-decade they were clients of his agency. Brian Friedman is clearly a bulldog snark machine as a lawyer, and some clients are going to want that. Some clients are going to want that representing them. I think if you are on Justin Baldoni's side at this point in our discussions of this particular topic, you're probably loving these types of quotes. But if you can imagine for just a minute that you're on the other side of this, that you see things from Blake Lively's perspective, and you think Justin Baldoni is essentially just trying to railroad her with legal claims, you can imagine how these quotes are rubbing her and her team the wrong way. Emanuel's remarks came one day after Lively and Baldoni rejected mediation, with both parties agreeing that settlement talks at this stage would be inappropriate and premature. So the way the legal system works in various jurisdictions is that we have certain ways that we try to keep cases out of court because the courts are overwhelmed with cases and can't really cover everything anyway. And so there are procedural points within our laws or civil framework that say, before we take this to court, before we go through this whole expensive, time-consuming process, you are going to try to talk this out in a room with a mediator or an arbitrator, depending on the jurisdiction, and you're going to try to solve this. In this particular case, what happened was both Lively and Baldoni, so this is one of the rare moments of agreement for the two sides, said, we're not going to do that. We want this to go to court, if at all, and that process should not be something that we have to go through, and so they asked the court to get them out of it. The legal dispute between the It Ends With Us co-stars began in December 2024, when Lively filed a sexual harassment complaint against Baldoni, accusing him of misconduct during the film's production. She also alleged that Baldoni and his associates engaged in a retaliatory smear campaign designed to destroy her reputation, claims Baldoni has denied. In January, Baldoni countersued Lively for $400 million, naming Reynolds and their publicist Leslie Sloan in a lawsuit that includes claims of extortion and defamation, among other allegations. That's an actually pretty good summary of the state of affairs as it stands right now. So good job to People. We give you full credit for that. Now let's dive into some more controversial storytelling from The Hollywood Reporter. So, The Hollywood Reporter is not just making controversial graphics for its cover, and here we see Freeman and Nicepool on the sides as promised. They're also writing articles about it. And this main article, the cover article, Justin Baldoni's Leap of Faith, is the subject of some amount of controversy on its own. We're going to talk about why in just a minute, but one thing I would ask you to keep in mind as we go through this is just who this is backstopping. Who is this providing cover for? Because I think there are different ways to read this article, and the different sides that I've already seen discuss it online have very different interpretations of what The Hollywood Reporter is even trying to do here. So, let's read Justin Baldoni's Leap of Faith. What role did the controversial director's Baha'i religion, and I apologize if I get that pronunciation wrong, play on the set of It Ends With Us? Did Wayfarer's missionary miscues, thank you for making that a tongue twister, Hollywood Reporter, help set the stage for Hollywood's uncivil war? I don't know. What do you think, Hollywood Reporter? Throughout the entire production of It Ends With Us, a persistent and peculiar rumor circulated on the set. According to this rumor, Justin Baldoni and It Ends With Us author Colleen Hoover shared a spiritual bond. Both were supposedly members of a small, obscure Iranian religious community known as Baha'i. It was this shared faith, or so the rumor went, that helped the 41-year-old director initially secure the rights to It Ends With Us. Now, why would you include that at the top, Hollywood Reporter, unless it was true? That's the only reason why you would have that paragraph to start this, right? None of that was true, continues the Hollywood Reporter. Hoover grew up in a small town in Texas filled with Southern Baptists, and a source close to the novelist insists she has never been part of the Baha'i community. Nor was there anything spiritual about the way in which the rights to Hoover's book were secured. Indeed, we saw emails that were put forth by Team Baldoni in his complaint, suggesting that it was a fairly normal book license rights conversation. Nor was there anything spiritual about the way in which the rights to Hoover's book were secured. It was Hoover's former editor turned literary agent named Johanna Castillo who brokered the rights agreement of It Ends With Us with Baldoni. According to a source close to Hoover, when the 45-year-old best-selling author became aware of the rumor shortly after the production wrapped, she was upset, but ultimately decided it was easiest to just let it go. Not entirely sure why she would be upset about that, other than the fact that it was suggested that she might have licensed this to somebody based on reasons that were outside of normal commercial things to think about. But yes, so the rumor's not true. So why did the Hollywood Reporter include it? Still, they say, the story is instructive, shedding some revealing light on what's been one of the most scrutinized and polarizing public feuds in recent Hollywood history. Very recent Hollywood history, since we're only a couple years removed from Depp v. Heard. For those who've been blissfully able to avoid the whole fracas, Blake Lively's December complaint with the California Civil Rights Department, which then became the basis of a lawsuit, was the opening salvo in this uncivil war. Technically speaking, while that is true from a legal perspective, I think the New York Times article is actually the opening salvo. In her lawsuit, she accused Baldoni and his partner Jamie Heath of all sorts of inappropriate behavior, including walking in on the actress while she was breastfeeding, using sexually charged language on set, and flouting industry-wide safety protocols and then orchestrating a smear campaign against the actress for standing up to him. Several additional lawsuits have since been filed, including 2 by Baldoni. He filed a $250 million libel lawsuit against the New York Times after it broke the news of Lively's allegations, which again, I have framed in this playlist as essentially the PR response to the initial volley from Blake Lively, because I don't think that particular lawsuit has realistically any chance of succeeding over the long term. And then a second suit against Lively, her husband Ryan Reynolds, and her publicist Leslie Sloan, seeking $400 million in damages and accusing them of defamation and other contractual claims, including extortion. A judge has set a trial date of March 9th, 2026. As you can see, I play a lot of board games. Thank you, aimed advertisements. From the outset, the Lively versus Baldoni feud has been framed as the newest chapter in Hollywood's ongoing fight for gender equality. It has rekindled increasingly dormant debates about sexual harassment and power dynamics, and that framing certainly could fit the facts. We'll have to see how it plays out in court. But there's also another possibility, one that has less to do with gender equality than it does a simple cultural misunderstanding. We saw Blake Lively's spokesperson say that cultural misunderstanding here was outrageous, that the Hollywood Reporter is essentially trying to provide cover for Justin Baldoni. Again, keep in mind, as we read through this particular article, which is a long one, I don't know which side this is providing cover for, and the reason for that is because of some of the negativity I've seen online with respect to Lively and her complaints. What, if much of it, the alleged inappropriate hugging and pre-filming praying, could be explained as a clash between a very specific faith-driven community with its unique mores and a much more modern post-Me Too one with its own set of beliefs and commandments? What if these are just people that don't really understand each other, and the discomfort that is described in Blake Lively's complaint is realistically just a discomfort with acting around and being in the presence of someone that doesn't think the same way that she does? Over the past several weeks, THR has interviewed multiple friends and former colleagues of Baldoni, along with members of the Baha'i community, to piece together if and how this religion might have inadvertently contributed to the situation. Baldoni, whose Irish Catholic father and Ashkenazi mother both converted to the religion before he was born in California and raised in Oregon, has made no secret about his devotion to the Baha'i faith, which is based on notions of humanity, universalism, and gender equality. What's also clear from talking to people in his orbit is that Baldoni has his own unique way of communicating and behaving, much of it informed by the tenor of his religion. It certainly seems from his complaint and even the statements that I have seen and video of him that I have seen that he is an awkward presence in person. I have not been in a room with him. This is all speculative based on what I have seen and heard, but it does appear like he is one of those people that we see in our lives from time to time that maybe just doesn't communicate the same way that we do or communicate in the way that we expect. That can obviously lead to a certain amount of discomfort. That doesn't mean that he can't also sexually harass or do very bad things to people and that he should be held accountable under the law. But it does mean there can be a disconnect between what he thinks he's communicating and what is actually being communicated to the receiver of his communications. And that could be a part of this conversation. But if you are looking at Blake Lively's complaint, you do think that she is put upon and was forced to operate in a sexual harassing work environment, this article to me does look like you're trying to provide cover, an explanation, an excuse for why Justin Baldoni acted the way that he did. His unique mannerisms have at times come into conflict with Hollywood's current ethos, which in the wake of Me Too and Black Lives Matter movements and the COVID pandemic has become far more rigid, uniform, and policed. I have to admit, Hollywood Reporter, I know you cover Hollywood, but I don't think of Hollywood movie making as overly rigid, uniform, or policed, but you do you. When analyzed through the prism of a 180-year-old faith that has a strong mystical component to it, at least some portions of this dispute start to make more sense. The Justin that I know isn't capable of doing the things that he's accused of doing, because he truly sees himself as this feminist. But Blake clearly got grossed out. Says a source who worked on It Ends With Us. I honestly feel like it was a perfect storm of two opposing personalities. Now this quote does two things, right? This quote is backing up Justin Baldoni. It's saying that I can't imagine him doing these things because he truly sees himself as what he describes himself as in the text that we've already seen, the cloying texts that I have discussed in this series, but also that Blake Lively might have legitimately felt uncomfortable, legitimately felt put upon. Not that a reasonable person would necessarily. Blake Lively might be the eggshell plaintiff. She might be overly sensitive to these things. We don't know. But at some level, when we're talking about hostile workplace, when we're talking about sexual harassment, you do take that eggshell plaintiff as they come. If they are overly sensitive to these things, that's a part of the discussion when we talk about legal punishments and legal frameworks. It's not the only part of the discussion. It still has to be objectively harassing. We'll see that as well. But this quote says both things. And then it says, I feel it was the perfect storm of opposing personalities, which again goes back to a kind of excuse making, a kind of cover for Justin Baldoni. You can see why Blake Lively and her team reacted so negatively to this cover story. When Baldoni and Wayfarer executives hold meetings, they often start by asking participants to go around the table and share something private, something that brings them joy and has nothing to do with their jobs or their career. Now, I can't speak to Hollywood movie making, again, but in my capacity as a professional, I have certainly been in rooms where we have some kind of icebreaker discussion to try to get things rolling, to try to open up communications pathways to get things done. I don't know that I would recommend it if everybody's high strung or in certain environments. That might be the case here. In certain professional circles, like say those of yoga instructors and doulas, this type of icebreaker might be welcomed. I have indeed had these icebreakers in boardrooms. But among time-crunched agents, entertainment lawyers, and studio executives, folks not exactly known for their touchy-feely ways, a gesture of this nature comes with risks. In my head, I was like, I'm sorry, are we at Cafe Effin' Gratitudes as a female executive at a production company who sat down with Wayfarer executives last year? Why are you imposing your culture on this meeting that's being held at our offices? I can't explain why, but it made me so uncomfortable. And certainly if somebody comes into your offices and does something differently that you're not expecting and makes you uncomfortable, that is something that you might well note. But I also did highlight this particular sentence because it is odd or ironic for Hollywood executives to say, why are you imposing your culture on me? When realistically, Hollywood is a culture machine that imposes whatever its values are at any given time on society at large. But it's just my 2 cents on that. Wayfarer Studios was founded in 2019 by Baldoni and billionaire Steve Sarowitz, another Baha'i follower, who invested $125 million in the independent production studio that aims to produce purpose-driven content. So I think this is a useful bit of reporting. This is good work from the Hollywood Reporter. I didn't see, even when I was looking at the Wayfarer website, this notion that it was designed around what we might recognize more in a Christian context as those types of film studios that make the God forgives or God loves me type movies. And that is what Wayfarer was at least originally built to do, as described by the Hollywood Reporter here. His first producing project in 2018 was The Gate, Dawn of the Baha'i Faith, a docudrama about the founding of his religion. I'm the money and he's the fame, Sarowitz said about his partnership with Baldoni in a recent interview with the website Inspired Insider. In addition to Baldoni and Sarowitz, Wayfarer President Heath is also a member of the Baha'i Faith, so this is a religious kind of grouping, as are several other Wayfarer employees. We think we're one human family, Sarowitz told Inspired Insider. It's not like we need everyone to be Baha'i. We want to just spread those teachings of oneness. And so that's what Wayfarer is doing. Then they say Zachary Hearn is a Baha'i and a professor of history with a focus on religion at Idaho State University, that the lack of a clergy or a priesthood allows for an immense amount of flexibility in interpreting the holy texts of this religion. So this is not the Catholic Church. This is not a religion that has specific tenets that you have to follow, or a priesthood that is going to tell you exactly what the various pieces of literature mean. It's very open to interpretation, at least, again, as described by the Hollywood Reporter. I pretend to have no expertise on this. Everyone is free to have and to explore their own interpretation, he says. Sometimes the message is explicit in the text, but members are urged to not go wild with their interpretations. But nobody has authority to say you're wrong. Nevertheless, there is a strict internal code. Central tenets include reconciling religious beliefs with science and strict equality among men and women. Premarital sex is forbidden, as is the consumption of alcohol or drugs, and prayer, fasting, and meditation are the main rituals. Even before it ends with us, Baldoni wasn't afraid to inject elements of his religion on the set. He did talk about his religion a lot, says a source who worked on the 2019 coming-of-age romance 5 Feet Apart, which Baldoni directed. My daughter loves that book. This has shades of Scientology, but with less of the prominence in people hovering at all times. Another source who also worked on 5 Feet Apart, however, has a very different impression of Baldoni and the influence of his religion on the set. I've never worked with a male director who was so worried about everyone's emotional and mental well-being, says the source. There was an openness and emotionality to his style that was more typical of a woman, and it probably wouldn't be an issue if it was a female director because of the preconceived notions of gender. But if you get a bunch of teamsters together who are told that they should share their feelings, of course someone is going to ask, why is he such a freak? But Justin genuinely believes that if we do this, we'll work better as a group. There's a little bit of an arrogance to it. It's like he doesn't want to acknowledge the world that we live in. Maybe. I wouldn't describe that necessarily as arrogance. We've certainly seen that he's very deferential to the others in his orbit in the text that he has shared. On the first day of filming, several members of the crew participated in a Baha'i prayer, according to a source. Other sources report that Baldoni frequently would ask for God for guidance before making big creative decisions on the film. Again, I don't see that as terribly unusual, even in my space. Various people in high levels of business to go and ask for whatever their spiritual authority is for help in making those difficult decisions. Generally speaking, they do that in their own office. They might say that that's what they're doing. They don't do it as a public prayer in the boardroom again. But I don't know, just based on this description, exactly how Justin Baldoni is doing that. Two more sources noted that there was an unusual amount of physical contact in the form of hugging among crew members. Okay, so that might be an issue based on what we've seen already in the complaints. The faith's principles and ideas are interpreted and accepted in a variety of cultural contexts, says Hearn. In France, followers might be more inclined to hug. In Saudi Arabia, less so. Lively's suit does not explicitly mention Baha'i by name, but the director's religious affinities guided many decisions that had been made on the set. According to her suit, Lively became alarmed when she learned that Adam Monsheen, the unknown actor Baldoni had cast as the doctor in an intimate scene in which Lively's character gives birth, was Baldoni's best friend. And we saw Baldoni in his response counter lawsuit say that he was well credentialed to be a lawyer, to be an actor, not a lawyer. And so there was no legitimate complaint about his presence on set. Turns out Monsheen was more than that. He was also a fellow Baha'i, whose biggest previous credit, and they mean movie credit here, because again, Baldoni's response was that he was in plays and was trained as an actor, had been The Gate, Dawn of the Baha'i Faith, also made by Wayfarer. In her suit, Lively also accused Baldoni of claiming that he could speak to the dead, and informed her that he had talked to her late father who died in 2021. That tracks with a 2017 video lecture Baldoni gave as part of the Baha'i teaching series titled What If Birth and Death Are Actually the Same? He has also referenced his interest in the afterlife in interviews. So what's described here, at least just from 30,000 feet as I see it from afar, does look like someone who is engaging with spirituality in a way that I personally would find unusual and probably off-putting in his presence as well. So that doesn't mean he's wrong. It doesn't mean that they're doing the very bad things that Blake Lively accuses him of, but it does potentially explain some of the discomfort that someone might have if you've got somebody that you track in your head as a real oddball that is your boss. According to Hearn, while there is a strong belief in the afterlife, the Baha'i writings don't say much about seances, noting that it is not encouraged to speak to the dead. It's a bit fringe for Baha'i. It wasn't just Baldoni who ran into issues when interacting with cast members. THR has learned more about the nature of the complaint that It Ends With Us actress Jenny Slate lodged. We'll talk about that in just a second. We'll get back to this paragraph. This is a big part of this story because there are a couple of additional actresses that Blake Lively, in her amended complaint, which we will read, has suggested have additional things to say about Baldoni and the way that Wayfarer treated its set that will backstop her complaints and ultimately win her the day in court on this particular question. This story, as described in The Hollywood Reporter, is, I think, rightly seen as something that doesn't actually help Blake Lively and is not what is articulated directly in the lawsuit, as we will see in just a minute. We'll get back to that because we have to get to the bottom of this article to see exactly why I'm pausing on that point. According to a source, Heath has a different understanding of their interaction. He's told people that even when Wayfarer offered a kind gesture, it was weaponized against them. There is nothing in the sacred Baha'i texts on how to behave on a movie set. Thank you for that clarification, Hollywood Reporter. There's nothing that addresses how to collaborate with an A-list movie star. But whether it was from his religion, his natural personality, or his self-admitted neurodivergence referenced in the court documents, people who have worked with Baldoni say that he tends to be deferential, sometimes too much so. Well, I have not worked with Justin Baldoni, but just looking at what he has provided as evidence so far, he seems so cloyingly obsequious and deferential that I would have to say that I agree with this assertion based on what I have seen from afar. Everybody is valuable no matter where you are in the hierarchy of the production, says a source who worked on 5 Feet Apart of a Baldoni's interpersonal directorial style. Everyone had the ability to bring up any concerns that are happening in our community. He liked to use that term, community. That deference, not surprisingly, opened up a power vacuum on the set of It Ends With Us, and Lively, sources say, was more than happy to step into that vacuum. And look, we don't know what these sources are. We have to take anonymous sources with a grain of salt, but just based on what we can see actually happened here, it does seem to suggest that Lively was more than happy to take over power with respect to this movie. One of the things that I said in previous videos in this series is that it did appear that there are people in the world, as we know, like potentially Blake Lively and Ryan Reynolds, that look at a soft underbelly, that look at a deference and say, that should be mine. I'm going to take over this. That's going to be that power vacuum that Hollywood Reporter describes here. But it also hurts Justin Baldoni's legal claims in his document because he's trying to set forth that Lively and Reynolds forced him to do something, forced Sony or him to lose control of the movie, did these various bad things under his extortion concept of the law. And ultimately, what I see personally as part of the documents that we have read so far is a man that was willing to give these things up. Is that willing to give these things up because he's afraid of sexual harassment complaints? I don't know. Is it just because he wants to be deferential and doesn't like conflict? That's a possibility as well. Either way, just handing over the reins to your movie isn't necessarily extortative in and of itself, isn't necessarily something that the law can help protect you from. At some level, we're all responsible for ourselves. And while there are laws that can be broken and harming us, it doesn't mean that if we voluntarily give something up, we can use the law to try to get it back or otherwise make somebody else's life a living hell. So like most things in Hangouts and Headlines and virtual legality, there's a lot of complicated stuff here. There's a lot of different ways to see these things. I just want to point these things out because I think that too often people go out on arguments online and discuss these things in terms of black and white, discuss these things as bright line differences. And I really do think we're looking at a set of lawsuits here where neither side has a particularly strong claim. And ultimately, it's a PR fight because when the settlement eventually comes, it's going to be up to the court of public opinion to decide who won and what the settlement, which will undoubtedly say nobody's liable for anything, actually means happened on the set of It Ends With Us. But Baldoni, says the Hollywood Reporter, is no A-lister. Sure, he made a name for himself on the television show Jane the Virgin. Not a name that I knew, but I'm just one person. And he has since directed 3 features, an episode of Jane the Virgin, and some short documentaries. Lively, on the other hand, has been a bona fide movie star for more than a decade. And again, why does your cover, if this is your cover story and you asked for the cover to be made, why is your cover depicting Blake Lively as David in David and Goliath if you're going to have this paragraph? She's on the short list of actresses prominent enough to convince a studio to greenlight a project, and with husband Ryan Reynolds, one of the most bankable actors in Hollywood, comprises one of the most formidable couples in the industry. Now here, I know it's the Hollywood Reporter, but I have to admit, I don't think there are many movie stars anymore. I don't think there are a lot of actors that are quote unquote bankable, that any idea, any script, any set of editors, any studio can make a movie featuring this actor and people are going to go see that movie because the actor's in it. And I certainly don't think Ryan Reynolds is one of them. But as I've said earlier in this series, I've never gotten a great vibe from Ryan Reynolds. That's from interviews and for other reasons that are more insubstantial than evidentiary. So you can take that as you will. But I really don't think that there are really any movie stars. I think even Tom Cruise, that has some success with things like Maverick, then doesn't have success with things like Mission Impossible: Dead Reckoning. So I think there aren't that kind of bankable stars that the Hollywood Reporter is really based on reporting of. According to several sources, Reynolds has been extremely active over the past few weeks, calling around to try and drum up as much support as he can among industry friends and colleagues. Now remember, this past few weeks from this set of articles is the past few weeks of our lives right now. So we're talking about the Saturday Night Live time. We're talking about all of this time that Blake Lively and her team are going to suggest was a time of emotional distress. There's nothing wrong with going and seeking out support in publicity and public relations. That's certainly what Justin Baldoni is accused of doing in Lively's lawsuit against him. But that in and of itself isn't wrong. And so I'm not going to hold Ryan Reynolds' feet to the fire for trying to drum up support, but it is noteworthy since he is a part of these lawsuits himself. Until recently, Wayfarer, Baldoni, Lively, and Reynolds were all represented by WME, which tried its best to broker an uneasy peace between its feuding clients. But when their simmering hostilities boiled over into an all-out war, it was no surprise which clients emerged on top. Shortly after the New York Times story appeared, the agency announced that it was dropping both Wayfarer and Baldoni from its roster, despite opposition from some agency insiders who preferred to remain neutral. WME's decision may have costly ramifications for Wayfarer, which stands to lose millions in potential revenue from impending projects like Pac-Man. I'm a little unclear as to what is being described here. I'm not sure why losing your agent for something that is already an impending project would cost you money. It's unclear in this reporting, but maybe someone in the comments can illuminate me. In his subsequent comments about this bad situation, Endeavor chief Ari Emanuel has added insult to injury, and this is in addition to the People article we just read. Appearing at the Wilshire Ebel Theater for a live podcast taping last week, Emanuel derisively referred to the director as baloney and lauded Reynolds and Lively for their warmth and charity. I've known Ryan and Blake for over a decade, he went on. They're really incredible people. In Hollywood, they've been incredibly successful. They've never had any bad press about them, and all the people they work with like them. So if it's true what they are saying in the allegation, those guys are two bad guys. And that, if it's true, that's lawyer and media speak, right? You put that in because you know you can't just say this thing if you don't think it's true, but you also don't fire someone if you don't think it's true. So that's an important part of the story. The demands made by Lively in her list of 30 demands, which we've seen at the top of the two complaints we've read so far, suggested that there had been instances of unprofessional and sexually inappropriate behavior on the set of It Ends With Us. And indeed they did, right? They used the phrase "no more" in a number of places to suggest that whatever we're agreeing to not have happen in the future happened in the past. I talked about this as a lawyer, that I would not have agreed to that particular bit of language. But that list, at least as argued by Justin Baldoni, was not a part of the protective agreement that they entered into. It was just a list of bullet points that Lively is said to have read in its entirety at that meeting. But again, that's just her saying that, and the other side disputes that that list was in fact read. So we've got a lot of fighting on perspectives here. He should never have signed off on that, says a source who's both friendly and sympathetic to Baldoni. But if you look at the statement, it doesn't say, "I will stop doing these things." It says, "I won't do this." There's a big difference. The Hollywood Reporter adds that a spokesperson for Lively pointed out that the January 4th document in question contained language that included the words "no more," suggesting that there was culpability. Indeed, it was written that way, but I don't know that that proves your case, spokesperson for Lively, because all we know is that that list was written by Lively and her team to read out at that meeting. So there is no agreement in writing to any of that. And so that's a part of this story as well, because even when in that first video, we noted that that opening paragraph to the complaint is odd because it just says, "This was discussed at the meeting and everybody agreed to address these issues." Last week at Saturday Night Live, we discussed this during an on-air question and answer skit hosted by Tina Fey and Amy Poehler. Fey asked Reynolds, "How's it going?" To which he responded, "Great. Why? What have you heard?" Prompting laughs as Lively looked on, playing the concerned spouse. And this is one of those areas where the internet, sometimes the highlighting doesn't work so well. The internet has a disagreement as to what was happening here, suggests that Blake Lively was surprised that that was Ryan Reynolds' response. I think that unlikely, and I think Hollywood Reporter's reporting here is more likely that Lively's in on it and is trying to act as concerned. The fact that you can't tell probably speaks to her acting, but I am not going to judge acting here on Hangouts and Headlines. It was a valiant attempt to deflect from the seriousness of the situation, but the reality is Lively and Reynolds are locked in a battle in which both sides see themselves as the aggrieved underdog. It's hard to believe from all the descriptions we've gotten of Blake Lively and Ryan Reynolds' collective power in Hollywood. Lively has shared with friends that she considers this a fight that's bigger than her, one likely to be remembered as the spark that ignited the next chapter of the Me Too movement. Now, as things are going right now, online and otherwise, she might be correct that this Baldoni versus Lively fight is going to be the next chapter of the Me Too movement. But I don't think right this second it looks like it's a chapter that is going to heighten or increase or improve the powers and authority of Me Too as a movement. It looks likely to diminish that movement as it stands today. On the other side is a billionaire producer, a novice film director, and a small group of Baha'i employees who believe they are simply living up to the moral code of their faith. Now, I promised you we'd go back to that important Jenny Slate story. The reason is because if we look at this editor's note to the Hollywood Reporter here, it says, due to a technical glitch, a portion of this story regarding Jenny Slate reverted to an earlier unedited version as has since been updated. THR regrets the error. So keep that in mind. This paragraph, this story that the Hollywood Reporter's investigators found themselves separate from the complaint that Blake Lively had made has been altered, and they say that it was a technical error that caused the alteration. We are going to look at prior versions of this to understand what happened and why I think it happened that way. So let's make sure we can get there. It is, as I said, a long article, and I should have highlighted it in a different color. My apologies there. We might just wind up searching for the word slate. It wasn't just Baldoni who ran into issues when interacting with cast members. THR has learned more about the nature of the complaint that it ends with us actress Jenny Slate lodged, which is referenced in court documents but with Slate's name redacted. It stemmed from an interaction with Heath about the apartment Slate had rented in New York City, where it ends with us was shooting. Slate, who has a toddler, told him she wasn't thrilled with the space she had rented, but that moving wasn't an option because she didn't want to lose the sizable security deposit, around $15,000. New York prices, man. A $15,000 security deposit on a temporary rental for a movie shoot is crazy to me. Again, I live in Michigan. I understand the Midwest is a different place than Manhattan, but $15,000 on a security deposit for a temporary rental. Heath informed Slate that Wayfarer would reimburse her for the lost deposit so she could find better accommodations. But apparently he made the offer using language that made Slate uncomfortable. Sources say he focused intensely on the sanctity of motherhood and Slate's role as a mother. According to sources, Sony became aware of Slate's concerns and informed Wayfarer about them. I've highlighted that in red because note the passive language, right? Sony became aware. From where? What are you talking about, Hollywood Reporter? Was it reported to them in a formal HR complaint? You've said that the complaint actress Jenny Slate lodged is what we're talking about here, but Sony became aware is something different. Of Slate's concerns and informed Wayfarer about them. A spokesperson for Slate did not return multiple requests for comment. So that's the story. So starting out with, that's not a terribly sexual harassment leveled story, right? We've got the ability to create a hostile work environment, as Blake Lively has alleged, with a series of anecdotal stories that are pervasive across the filming. But this, Jamie Heath offered to cover my security deposit of $15,000, but said too much about motherhood, is not the greatest form of backstopping of what Blake Lively has alleged happened on the set of It Ends With Us. You add on that it seems like there is a space between Jenny Slate lodged a complaint and Sony became aware, and we have the same issue that we noted when we looked at Blake Lively's original complaint, which is that they seem to skip the place where they say that a formal HR process was initiated, which of course is necessary for the retaliation side of the allegations to kick in, but they skipped it there in that first complaint by saying that Wayfarer was of course never going to investigate what it was that we said to them. So we just talked to the rep for Sony and didn't otherwise go through an HR process because they didn't have one. Here, we don't have the idealization of a formal complaint here, which suggests to me as a lawyer reading this that one probably doesn't exist. But that's also because I'm cheating a little bit and I've seen the changes that they've made to this paragraph. So let's bring everybody up to speed. So as Zach Peter on Twitter/X has noted, there are 4 different versions of the Hollywood Reporter's article as it stands right now. And only in the last one did they add this editor's note that we looked at in our analysis of this article. And Against the Tide, again, sent me a picture pointing out these various differences. The biggest one is what is described for Sony's part of this story, where the first version that was published of this particular article said she filed a complaint to the film's distributor, Sony. Then version 2 said Sony, the word got back to Sony. Version 3 went back to saying she filed a complaint with Sony, but changed some of the punctuation and dash markage. And then it got back to Sony became aware. So it's clear to me that there's definitely a hole in their investigation, the evidence, the paperwork, the paper trail about whether or not Sony was actually formally told about this particular issue. And if I'm guessing from a corporate lawyer standpoint, the original version of this article would have offended Sony's corporate lawyers if they felt that they never got a complaint like this. If filed a complaint is not accurate language, then Sony's lawyers get upset because they don't want to be on the hook for an inadequate response to a report that they never received, right? And it's possible that this was the original way that it was written, but it wasn't intended to be published this way, and that Hollywood Reporter was already solving for these issues because Sony had responded based on emails that they got to an earlier preliminary copy of this article, and they did publish the wrong version. There's a lot of back-end stuff that could happen wrongly, but the fact that it goes 2 more iterations is suggestive of real communications issues on this particular point. But ending here as it is right now, with Sony became aware, strongly suggestive to me in my reading that Sony did not get a formal HR complaint on this particular topic, which, as I said already substantively, is not a particularly strong backstop to what Blake Lively and her team are alleging happened on the set of It Ends With Us anyway. So this is, as the lawyers among us would say, weak sauce, right? We don't have any kind of strong backing here, and that's going to be a part of our reading of the amended complaint when we get to it. Now, that's the end of this particular article. That's the cover story. We see that Justin Baldoni is given some cover for his religious faith, but it also seems to be providing cover to Blake Lively insofar as if you have turned against her on this, if you think that she is saying too much out of school about what happened and that she's not believable because you've seen the videos of her interviews, you've seen the various other aspects of what's out there, then maybe she's getting cover because it's reasonable for someone to say, look, I've been uncomfortable with kind of neurodivergent individuals, or I've been uncomfortable with people that aren't communicating in the way that I expect in various circumstances, so I can understand why maybe that got too far. So I look at this particular article as the Hollywood Reporter doing Hollywood Reporter things and basically trying to cover everybody at the same time. Nevertheless, Blake Lively's spokesperson went out there and said that the article is against her and ridiculous, and seems to be taking an aggressive approach to even this coverage, which I think is largely helpful to Blake Lively, as well as Justin Baldoni. Then we get one that is definitely not on Justin Baldoni's side, despite the headline. And again, this was a package of articles that the Hollywood Reporter put under its cover story in this most recent edition. Why Justin Baldoni's attorney can't lose. Brian Friedman is the attack dog for powerful clients he portrays as underdogs. In today's court of public opinion, where narratives of oppression rule, it's often a winning strategy. So, looking at that subheadline, right, the first thing you note is that they are portraying Brian Friedman as a kind of liar, a kind of person who's a bit slimy. He's the attack dog for powerful clients, but he portrays them in a way that they are not, as underdogs. And that might win, but you should think of him negatively. You should think of him with your eyes askance. His lawyer, Brian Friedman, is already victorious, regardless of how this works. Put aside the billable hour payday. He's already going to make a fortune because he's a lawyer. Baldoni's co-defendant and partner in production company Wayfarer, the billionaire Steve Sarowitz, has reportedly pledged $100 million to their defense. So he's going to make bank however this goes. And as we say in lawyer land, the only party that really always wins are the lawyers. It's a testament to Friedman that so far his client's battle with one of Hollywood's most powerful couples, again, you depicted her as David on your cover, still remains a draw. Many observers expected Baldoni to apologize and quickly disappear after Lively cold-cocked him in December via a blockbuster New York Times story, co-bylined by Megan Twohey, one of the key instigating reporters of the Me Too movement. Instead, Friedman went on the warpath. And you can understand why that first paragraph is the way it is. Having seen Justin Baldoni in action, he's been deferential in almost every instance. He agreed to sit aside for the own premiere of his own movie that was funded by his own studio. And so it is the kind of thing where if you're Blake Lively and Ryan Reynolds and you believe that, even if you believe that you've got a bit of a case, that he's going to back down in the face of anything that you leaked to the New York Times, instead it didn't work out that way. Friedman went on the warpath. Lively's legal team begged a judge to rein him in. Meanwhile, Baldoni, who in recent years had emerged as one of America's foremost male feminists, has received crucial support from an ideologically unlikely mix of supporters with massive media platforms. And one thing in common, they're also Friedman clients. Now, I've covered this because I was interested in the New York Times story, and the sourcing that I could see was pretty clearly, to me, Team Lively leaking out the complaint because there was no reason that anybody would find it in California when it was filed, certainly not the day after it was filed. But I'm also not a member of a massive media platform, unless you count YouTube as the entirety of the platform. And I'm certainly not a client of Brian Friedman. So I am looking at this as objectively as I can. And as you can probably hear during this playlist, I am becoming more and more convinced of Justin Baldoni's description of the events as they happened, rather than Blake Lively's. That's entirely my own reason. I'm not being paid by anybody. I'm not a part of some kind of PR campaign. And yet, part of what we're going to see in the amended complaint, part of what we're going to see in various versions of these articles, is this assumption by Blake Lively and her team that any kind of negativity, any kind of criticism of her complaint, her stance, or maybe even the marketing that she did of the movie must be inorganic, must be being bought and paid for by a shadowy Texas consultant or a director in Justin Baldoni. Friedman has always seen himself as the attack dog for the underdogs. Sure, he may represent wealthy figures known for their fame and charisma, but his most notable battles have typically been waged against large corporations whom he views as the true Goliaths. There's always a bigger fish, right? You can always frame your person as an underdog to some extent if you can find a bigger person to fight. In this dispute with Lively, he sought to portray her as the establishment figure, part of an insidious and powerful Hollywood web, along with her pop star friend Taylor Swift, or perhaps former friend if the tabloids are to be believed, and more consequently, her actor-producer husband, Ryan Reynolds. Litigating as he often does in the court of public opinion, Friedman knows that people prefer to identify with scrappy outsiders against institutional insiders. Katniss Everdeen, Luke Skywalker, Aaron Brockovich. His MO is to position his clients and himself within today's favored narratives of oppression and marginalization. He's told THR that his intense protective streak can be traced to unspecified childhood trauma. In Friedman's framing, Lively is the popular mean girl, Baldoni the guileless, picked-on good guy. He does appear to be guileless for the most part. Of course, an important part of fighting in the media is fighting with the media. While Friedman feeds his favored press outlets tip-offs on filings and colorful statements, confident, friendly voices on social platforms will in turn amplify his message. Those who run counter to his interests know they'll face his ire. Yashar writing an article about you. Friedman wrote me, the author, about THR published coverage he didn't like about his earlier litigation against Baldoni for alleged script theft from a man with cystic fibrosis. There's a lot in that sentence, isn't there? So, Yashar writing an article about you is a reference to Yashar Ali. We'll see that as part of this paragraph. This is a sentence that is trying to state that this lawyer for Justin Baldoni is a bulldog. He attacked me personally, the author of this article, while I was trying to cover his client, who happens to be the subject of this particular story, Justin Baldoni, for stealing a script from a man with cystic fibrosis. So we can sneak in that Justin Baldoni might be a bad guy, and Brian Friedman certainly is a bad guy because he's threatening me while I report on this thing that happened. The subtext wasn't subtle, claiming to have deployed a former client, the online influencer and self-styled muckraker Yashar Ali, against a wayward member of the press, which is himself in that sentence. Friedman had previously represented Ali in a failed defamation suit against THR co-editor-in-chief Mayor Rashomon when he helmed Los Angeles Magazine. So he's a bad guy. He attacks us all the time. Later, when Friedman learned that THR would be scrutinizing his relationship with a controversial consultant whom Lively had accused of plotting to unfairly warp social media sentiment around the conflict, he protested that this publication was in league with Reynolds because his Deadpool and Wolverine business partners, Disney and Marvel, advertise in THR. And so the end of this paragraph is framing Friedman as essentially making insubstantial arguments against us at The Hollywood Reporter. Obviously, our editorials are above scrutiny for just advertising of a Disney movie. That's not to be unexpected for people that cover the Hollywood business industry. So the design here is he's a bad guy. He tried to attack us for covering his client stealing a script from a man with cystic fibrosis. And he did it with a muckraker that you shouldn't trust online, which is his client. And then he also tried to accuse us of being against his client and in favor of Blake Lively for doing something that anybody would do, which is to accept advertising bucks from Disney while they advertise their latest Marvel movie. Friedman's noisy belligerence, and note that language there, again, setting in tone that this is a bad guy that you should suspect, sets him apart from his more buttoned-down Hollywood legal peers. And while some professional colleagues recoil at his style and even his substance, it's endeared him to clients who appreciate his willingness to engage in today's variant of public trial by combat. And I think this is a fair paragraph insofar as different lawyers approach these things differently. You've probably seen that even on LawTube, as it were, with different of us looking at things from a different angle as we look at live trials or even commenting on the same legal disputes at the same time. And different clients are going to ask for different things. There have been clients that have called me up or have met with me and said, I want a bulldog that'll take no prisoners and absolutely eviscerate the other side in a contract negotiation or similar, and I will talk them through depending on what it is that they're asking for and say what I'm comfortable with doing and what I'm not. And different clients want their representatives to be representative of different things. And this is clearly one of those lawyers that will go out there and attack and will go and stand on the courthouse steps and say, my client has been vilified. And it's time that the actual people that are requiring justice get that justice served to them, etc., etc. For Friedman, though, win or lose, the result is never Pyrrhic. His legend and his practice's docket only grows. So, at the end of the day, this is lawyers, man, as an article. So they've got religion, man, and lawyers, man, as part of this package. But what we haven't covered yet is public relations, man. So let's see what else the Hollywood Reporter has for us. Lively versus Baldoni has already changed Hollywood publicity forever. With publicists caught in the crossfire in the industry's biggest scandal, insiders say the case has had an immediate impact on their business. Yes, we would expect that. When they start to whack the lawyers, that's when I draw the line. Fretted attorney Saul Goodman in an episode of Breaking Bad after one of his colleagues was murdered. One of the things I love about the Hollywood Reporter, I mean this sincerely, is that they're always framing whatever story they want to talk about in the context of what they already cover, in this case, TV shows. And as the inventor of virtual legality, designed to talk about important contract and business issues through the lens of video games and pop culture, I respect it because I do think it makes it easy as an entry point to discuss real things with reference points that people can recognize. A similar anxiety has now gripped some members of Hollywood's publicity class amid the Baldoni-Lively legal battle, in which several top PR names have become major players in a war that has riveted the town. According to several personal and studio publicists interviewed by the Hollywood Reporter, the scandal has already changed how representatives who are not involved with the case operate. How so? This will change the personal publicist game forever, 100%, predicted one veteran personal publicist. When a client says, I want you to protect my reputation and get ahead of the story, or I don't like that headline, can you call the reporter? No way. If what you're doing has ramifications for another celebrity, you're not going to think that you could get sued. Now, in fairness, you should have always thought that if you are in the public relations, public communications game of any type, including me, then you have to be thinking about how you might damage the reputation of another. You have to be careful with your words and try to be as truthful as possible. That should always be the case. Take, for example, one of the claims in Baldoni's lawsuit, that Lively's publicist Leslie Sloan lobbied a Daily Mail reporter back in August to change his story. The reporter planned to write that an internal power struggle between Lively and Baldoni on their film It Ends With Us had resulted in the actress being labeled as difficult. Sloan insisted via text message to the reporter, you have it all wrong. The whole cast hates Baldoni. Sloan's efforts to change the story were allegedly successful. I mean, the story was not what you first reported just then, but as any reporter can attest, a publicist giving additional information on background to try and make a story more friendly to their client isn't some rare event, but is extremely common. That's their job, personal publicist. Now Sloan is among those being sued by Baldoni, while Lively is suing Baldoni's crisis manager, Melissa Nathan, along with publicist Jennifer Abel. I feel bad for them because some of the things they were asked to do are just things that are done by about any publicist would have done without question as the veteran publicist, but not now. Now, I don't think it's a bad thing for people engaged in a profession, whether it's public relations or otherwise, to be aware of the legal liability and exposure that they have in doing that profession. Honestly, they should have been aware of this from the front. That said, I don't think that now is necessarily the time where you have to make these changes to everything that you've ever done as a publicist if you're not directly involved in this particular case, because we haven't seen which direction this case is going to go. There are entire swaths of the complaint from both Blake Lively's side and Justin Baldoni's side that I think are probably going to get kicked out, that they're just public relations people doing public relations thing, that's not illegal, and that we have a very strong First Amendment freedom of expression ability in the United States that is going to have most of those things removed from play. We're also going to talk in just a minute about Blake Lively's amended complaint and how at least one of the aspects of that complaint is likely to be kicked out as well, as, again, potentially violative of the First Amendment freedom of expression in the United States. So I don't think now is necessarily the time to move, but I think it's always a good idea to be cognizant of the legal exposure that you have doing whatever it is that you're doing in whatever jurisdiction you're doing it in. One longtime studio publicist notes, I think good comms executives will always have plans in place to help protect their clients, but now they have to ask themselves, if their strategy is leaked, would they still stand by it? Protecting a client and playing defense is one thing. Targeting others proactively is completely another. I think that's probably right as a delineation, although I would note that Lively's complaint does not make that distinction. Defense, essentially increasing the positive exposure of their own client, Justin Baldoni, is not treated any differently or any more legally in the complaint that Blake Lively has put forth than is the more aggressive takedown of Blake Lively and her reputation that is alleged in that document. In addition to the reputational harm and humiliation that might come with a lawsuit, some personal publicists are also concerned about racking up financially ruinous legal fees. Yeah, the lawyers. They always get paid, man. Studio publicists are typically protected from being sued by their companies. Large PR firms likewise require indemnification. So this sentence is true insofar as it goes, but also you got to be careful here. Studio publicists are protected from being sued by their companies is not a contractual thing, right? The companies don't necessarily agree that they won't sue them. It's just not going to make sense for most companies to sue their employees. One, because that's discovery of what they were ordered to do in the first instance. Two, because it makes it hard to hire new people into your company if you're in the business of suing your employees that either didn't do what you wanted them to do or did what you wanted them to do and opened you up to legal exposure. So typically protected from being sued by their companies by virtue of their standing in the company, yes, but not by contract, which is what we're talking about with respect to indemnification. If you're not familiar with the term indemnification, I don't blame you. It's a very legally term, but basically indemnification is the concept that I can have a contract in writing that says you are going to pay for my damages and potentially the cost of a legal pursuit if a third party comes after me for what I'm doing on your behalf. So a large PR firm you hire, you get an agent that you like, and the contract with that PR firm says, if a third party comes out of the woodwork and accuses us of doing something bad, you will indemnify us for that entire legal process. I wouldn't even pick up a phone for a client without indemnification, said one well-known major agency representative. Sometimes a prospective client's lawyers try to redline that out. Yes, they would, because that's an area in which the client could be exposed themselves, but we don't take them on as clients without it. And that's what negotiation is about. This is what I do for a living, is talk about terms like indemnification provisions. But some independent personal publicists or those who work at small firms don't have such protection. Their clients can be multimillionaires with extensive resources, yet they pay as little as $5,000 a month, as little as, right? And don't indemnify their representatives in case something goes wrong. While A-list clients at major agencies often pay closer to $10,000 a month. The whole relationship is based on trust, the veteran rep notes. Yes, if you have a higher standing, if you have more organizational protections, you can go and ask for more things in your contract. Generally speaking, if you're starting up, if you're a smaller operation, you're going to ask for less. When I went from big law to holding my own shot, I ditched a lot of the provisions in the engagement contract that I felt were unnecessary and were preventing clients from signing on with that original big law firm. And that has proven to be a good choice for me so far. But that's essentially because I get to choose my own risk profile when I make those decisions. In a big organization, you're not choosing how that engagement letter looks. There is zero legal protection for us, and the Baldoni case does make me more afraid. This is a longtime personal publicist who segued from working at a major agency to launching their own boutique company. This publicist admits he's not proud of the things they've done to hide client behavior in the past. A lot of the times we are at the mercy of the people who pay our bills, the publicist says. Not entirely. You can always fire your client. When I worked at a major PR agency, we were instructed that the client came first and their money came first. So if the client told us to do something and they were paying for it, then you do it. Now we are all being cautious. This, by the way, is why professionals have ethics rules, and they may not be as strong for public relations professionals, but when you think about professionals in medical ethics and legal ethics, that's why we have these rules, is because we do get into these situations where we are a representative of the client. The client asks us to do something nasty, and we have to have our own ethical grounds for deciding whether or not we're going to do those things with, again, money offered to do them, and it becomes something that you have to really think about. I pride myself on trying to do the best for justice and not do these things that clients sometimes ask for, and keep a client book of clients that I can trust to not ask me to do things outside my comfort zone with respect to legal actions. But I am blessed to have enough resources, enough money, enough experience, and a history of success to get the clients in the door that I need to have a functional operation. Not everybody has that blessing. The boutique agency owner notes that the Baldoni case has also impacted his business in an entirely different and unexpected way. I had a prospective client say to me, because of this, I don't know if I want to get a publicist right now. I don't want people thinking I have something to hide. This publicist isn't a crisis manager, a branch of publicity known for aggressive and secretive tactics, but notes such distinctions are not widely understood. Clients don't see the difference. They think that that's what we do, sit in our ivory towers and look for who we can take down to get our clients ahead. Note that this paragraph is very anti-crisis manager, which is a role that I have said in this space and others on my channel is a role that I think is necessary and useful, and isn't necessarily aggressive and secretive, although many of them are, but they are also a branch of publicist. So this publicist isn't a crisis manager, just means that they don't specialize in that. It doesn't mean they couldn't manage a crisis if they were called to do so. So this is essentially a version of the Hollywood Reporter trying to throw somebody else under the bus to defend publicists in general. But again, this is an area in which the Hollywood Reporter is reporting on just various different professions that have been impacted by this story. All comms folks are taught from day one, never put anything in writing you wouldn't want on the front page of the New York Times, she says. This has been a reminder of that all-important rule. And yes, I've said it in this space and on this playlist. There are a number of these text messages that have been found that are things that you would not want to put in writing. And in writing means voicemail, in writing means text message, in writing means anything that can be reproduced in a place that you wouldn't want it reproduced. Now, the one thing that I did want to comment on when I highlighted this was that all comms folks are taught is maybe a little bit aggrandizing of public relations as a profession. I really think all children are taught at this point that if you're going to put something in writing, if you're going to put something in something that can be reproduced elsewhere, you should assume it's on Facebook. You should assume it's in the New York Times. You should assume that it is public so that we teach our kids to be more cautious with their communications. So I don't think it's just limited to public relations professionals. I really think this is something that children are taught or should be taught right now, and is something that really, to interact with people in the 21st century, you need to know when we're talking about what conversations take place. One of my publicist friends said their clients are literally saying, please don't talk bad about me to other publicists, because clients now think we tell other people how shitty they are. What was an industry of helping and protecting and elevating people, it's a very noble take on public relations, is going to change. The whole sheen has been tarnished in a way that's not justified because there are a lot of great publicists doing a lot of great work out there. I'm sure there are, by the way. I'm sure that there are a lot of great publicists doing a lot of great work out there. Yes, that is, in a manner of speaking, helping and elevating people insofar as you're getting their Q-score up, you're getting recognition for whoever your client happens to be. I don't view it as noble as, say, the medical profession, but it does apparently need a set of ethics rules that are pretty heavily imposed in order to avoid some of these problems and to make sure everybody's above board in the way they represent their clients. That is the last of the truly substantive new opinion editorial reporting that Hollywood Reporter did on this particular topic. I hope that conversation was useful to you. They also did a fairly good job, not an entirely completely good job, of putting forward a timeline of the Baldoni-Lively fight, which I thought would be useful for us to go into before we get into the amended complaint, just to remind us where we've been and where we're going so that we can better be prepared to dive into that amended complaint as it stands. But before we do that, I'm going to take a little bit of a brain break here for just a moment so that I can rest my voice for a second. Let me know what you think in the comments. I'll try to grab these stars before we go forward anymore. And we can talk about any questions you have, any other thoughts you have, anything you think I got wrong, anything you think I got especially right. I'm happy to get any comments that you have. As Just Because says, one of those comments is don't forget to like the stream if you haven't already. Please do like. Subscribe if you like this content. We like to have these conversations here. I like to have these streams with you all. Usually, a video like this in Hangouts and Headlines would have an opening Hangouts period where we would talk about something that the community was facing or questions that I had or just the weather in the various places around the earth. We don't get to do that when I have this much content prepared, and I apologize for that. But please do like the stream if you haven't already. Thank you so much, Just Because. Emily Aarons, thank you for being a member for so long. Good morning, Hangouts and Headlines family. Nice to see you all. Red heart emoji. Thank you, Emily Aarons. Nice to see you. I'm glad that you're here in the chat talking over these important issues with us today. Michael Johans, 1. Thank you so much for the super chat. Watching from Norway. Love your balanced coverage no matter the topic. Purple heart or blue heart emoji. Thank you so much. Michelle Johan, sorry for calling you Michael immediately prior there too. I appreciate the super chat. Thank you so much for the support of the channel. Just Because with another chat. A super chat. Feels odd for them to pull Baha'i in when, if I recall correctly, the big introduction of it to the mainstream was Rainn Wilson talking about it 10 or 15 years ago. I don't know anything about Baha'i or its relationship to Hollywood. I didn't see that Rainn Wilson talk. That's Dwight on The Office, to those of you in the know on that particular show. But it might well be that he did have that conversation. I think they brought it in, honestly, because they are trying to provide a way for both of these sides to get out. It's clearly gone more scorched earth than either side was expecting at this point in time. And I think the Hollywood Reporter is looking at this and saying, guys, you're destroying Hollywood. Please stop, and trying to give them a way out. Clearly, Blake Lively and her team are not going for that. If the quotes that the spokesperson gave to Us Weekly are any indication on this particular topic. But I believe, looking at that article from 30,000 feet from the outside in, that it was an attempt by the Hollywood Reporter to give cover to both sides, that Justin Baldoni is just a nervous Nelly. He's an overly religious spiritual guy. That's not what Hollywood is used to. And yes, that can make people uncomfortable, but probably wasn't sexual harassment. And to Blake Lively, hey, look, we understand why you would have been uncomfortable with some of this stuff. We're going to mention the hugging and all these various other things. But realistically, the reason this is going so negative for you right now is because he's a weirdo and you should just drop all of this and we should get back to the important business of making movies. I mean, movies. Yes. Making movies in Hollywood, not money, movies, doing art, having a commercial responsibility. And that's, I think, the purpose of that cover article. I think Team Lively is a little bit agitated on all these fronts that we've seen them react to online. And so it didn't work to that extent. Joe Beer, thank you so much for the super chat. I have to say I'm still on the fence with this one. I agree. I learned with the whole DVH case, that's Dep V Heard, to not make up my mind until all the evidence is in. Hugging, smiling emoji. I could not possibly respect that position more. Like I said, I'm starting to lean towards Baldoni insofar as I think he's got the more effective case presentation so far. His version of events, the story that he puts forth as what happened, makes more sense to me. And as we will see when we look at the amended complaint, I think that the chance to shore up Blake Lively's position has likely passed, and that the amended complaint does her no favors in that regard. And we'll talk about that when we get to it. But that's where I see things right now. Christy Fletcher, thank you so much for being a member for so long. Happy to spend some time on my birthday with Hoeg in the chat. It's your birthday. Happy birthday, Christy Fletcher. February birthdays are great. I love a February birthday. So thank you so much for being here with us. I hope it has been informative and educational. Let's see if we've got some other chats that I can pull up. If you want to flag it for me, please type Hoeg or Hoeglaw or Q for question and colon. Anything that I can see there makes it a little bit easier when there is a lot of chat happening. Just trying to scan the chats right now, so bear with me for a little bit of silence. Heather McGregor says, it's been a while since I've joined for Hangouts and Headlines. Used to watch religiously, but fell off a bit. Well, so did I, so you weren't missing many. Glad to be back, and we'll join more. Happy face emoji. Love the takes. Thank you, Heather McGregor. I really appreciate it. And it's totally okay for you to have missed a bunch of Hangouts and Headlines in the last year, because I think there's probably only a half dozen or so. Pacha says, I like how you view these items. You seem to try to be very even-handed, but you can make a judgment also. One thing I don't want to leave you with when we do these conversations on an article or on a legal document that we're about to do is this notion that lawyers can easily get into where each side is equal. There's all these different views and possibilities, which I definitely put forth, but that you thus can't ever make a decision, because not only is that not true, it's definitely not what we ask judges and juries to do, right? We say that reasonable minds can differ, absolutely, but that if a jury member is just a layperson, not a lawyer, not trained in any of these things, is faced with these sets of facts, they have to determine what actually happened and whether a law was broken. And so I do want to say, when we get to a certain place, that I feel X about this particular aspect, or I feel Y, because I think that's my job here in this space. I just don't want you to come away from these videos feeling like I am telling you how to feel about these things, because there are a lot of different ways to see these things. I will see them one way, just like you will see them one way, and you can agree with me and you cannot agree with me, and each is okay. The chat is having conversations about various aspects of the evidence on social media, as I suspected they would. I do apologize for not covering those things in detail here. It's just not what I view as my bailiwick. It's not what I'm good at, and it's not, I think, a useful expenditure of our time together. So absolutely go check out whatever it is that you want to check out on social media and in the various other places on the internet that has pulled apart these various videos and interviews and things related to Blake Lively and her career, or Justin Baldoni and his career, and make your own determinations on that score. Just keep that critical thinking hat on, remembering that reasonable minds can differ even in that space. I won't be covering most of that stuff here. All right, and I think I'm going to leave the chat to its conversations on those topics, and we're going to get back to talking about what the Hollywood Reporter refers to as the Rashomon of our times. Now, we covered Rashomon in an earlier video in this series, but that is a movie from Kurosawa, I believe, that discusses the way that different people can see the same set of events from different perspectives and come to different understandings of what happened. I do think it's a good metaphor here for this particular story because, as I have said when reading all the complaint documents, there are at least kernels of truth with what Lively alleges. Even if you want to think Baldoni is in the right here, Lively's allegations have been backed up by Baldoni's countersuit insofar as the things that are alleged to have happened, but the context of their happening is where these things differ. That at some point Baldoni did say to Lively that she's hot or she would be hot, and Lively describes that as being something that she took offense to, as being sexually charged, etc., creating a hostile work environment. And Baldoni explains that it was because what she was wearing was a coat over a onesie, and he thought that she literally would be hot under the lights, etc. And reasonable minds can look at those and say, yep, that's plausible, and yep, that's plausible, and then have to take all the rest of the evidence into account to decide which is the more likely to have happened. But it prevents us from being able to say from the outside in, without looking at the direct evidence. There hasn't been discovery, there hasn't been a trial yet, obviously, what exactly happened from the perspective of a jury or a judge. So I do think Rashomon is a good metaphor here, and I would keep it in mind that even in a case with eyewitnesses are known for being kind of not necessarily deliberately lying, but inaccurate to the point of omission, to creating ambiguities in what actually happened in a crime scene or otherwise because of the nature of human memory. And when you frame it out with all of this kind of tension and clearly a desire from the Lively side, whether that happens as a result of the sexual harassment or non-existence of sexual harassment, or later on is going to be a fight that we see in the amended complaint, to take over the movie, is a part of everything that's happening. Or as The Hollywood Reporter says, one narrative tells the story of sexual harassment and retaliation by a filmmaker backed by a billionaire, funding a shady cabal of crisis PR professionals. The other is the tale of an A-list actress, aided by some of the biggest celebrities in the world, scheming to rip away control of a director's passion project and destroy his reputation. That's a good paragraph. That is a quick Cliff Notes version of what is happening here. Those are the two perspectives, and where you come out on this is going to be based on how much you read and how much you look at the various other aspects of people's interviews and relationships and decide that that's going to be informative of what happened on this particular set on these particular days in 2023 and 2024. The first hints of conflict, I happen to have a few dragons. April 2023. After years of development, the pieces for the movie finally came together. Sony boards to distribute and co-finance, with Lively is cast as Lily. She and Baldoni work on building rapport ahead of filming via long text messages and conversations. However, creative tension builds. Lively suggests script changes for a rooftop scene at the beginning of the film and invites her director to her New York City residence on April 12, 2023 to discuss. Baldoni is surprised to encounter Lively's husband, Ryan Reynolds, and friend Taylor Swift, with the two megastars praising the actress's version of the scene. The filmmaker feels pressured to accept the changes, according to his lawsuit, and texts Lively afterwards that he didn't need the duo to weigh in, as he likes her take on the scene. On April 14th, Lively texts Baldoni that Reynolds and Swift are her dragons, referencing the Game of Thrones character Daenerys Targaryen. If you ever get around to watching Game of Thrones, you'll appreciate that I'm Khaleesi, and like her, I happen to have a few dragons. The text reads, for better or worse, but usually better, because my dragons also protect those I fight for. Now, this is a strange text message, right? We talked about this when we first saw this recorded in the complaints, but this is a strange text message, not just because it's kind of insane to talk about your friends as if they were monsters that are at your beck and call, but also because, spoiler alerts for those that don't want to be spoiled on Game of Thrones, Khaleesi, at the end of the day, uses her dragons in a not terribly Geneva Conventions authorized way, right? The dragons of Daenerys Targaryen, not good at the end of the day. And this is years after that would have taken place in the fictional world of Game of Thrones. So using it in this context is super strange. And I don't know whether that means that she just didn't get around to seeing the end of Game of Thrones, or whether she's just comfortable being the queen who burns the civilians down in order to take over the world. But either way, it doesn't play as particularly strongly for the Blake Lively contingent of this story. The back and forth over the scene rewrite also led Baldoni to send Lively a 6-minute plus voice message at 2 a.m. to apologize for anything he did to upset her. At the end of the recording, Baldoni says, you probably have kids all over you and a baby on your boob, and you're listening to me ramble at 2 in the morning. And again, this voice message, same thing that we saw from the public relations article. This is not the kind of thing that you want to have on a recording that can otherwise be shown in another context against you. All of this is very cloying. All of this is very deferential. I do not recommend listening to this voice message. I'm certainly not going to listen to it here on my channel, but it doesn't play terribly well for Justin Baldoni insofar as it doesn't look like he's taking command of his set, but it also doesn't play very well for Blake Lively insofar as it doesn't look so much like he's trying to harass her as he's just a weirdo that doesn't know how to communicate with people. Allegations of improvised physical intimacy. On May 16th, 2023, Lively experiences what she describes as her first instance of sexual harassment on the set. So this, what she describes is, good Lord, Hollywood Reporter. This, what she describes is the same as saying allegedly in legal context when we're looking at these types of articles. So you're going to see a lot of references to what's in the complaints, what these people are saying about each other in this particular timeline. When Wayfarer CEO Jamie Heath arrives unannounced at Ms. Lively's hair and makeup trailer while she was topless and having body makeup removed by makeup artists, according to her lawsuit. Baldoni claims in his suit that Lively was not topless, and any suggestion that Heath stared at her inappropriately is not only blatantly false. That's not a complete quote, Hollywood Reporter. In another instance, Lively alleges that during filming, Baldoni improvised physical intimacy, such as a slow dance sequence. We're definitely going to get to that in a minute. Where Mr. Baldoni was caressing Mr. Lively, Ms. Lively, with his mouth in a way that had nothing to do with their roles. In January 2025, Baldoni attorney Brian Friedman will leak behind-the-scene footage of the scene in question, which they say disproves Lively's allegations. Again, the video is out there. You can watch it at your discretion. And this is one of those interesting areas where, like Rashomon, you've got video of what happened. And Team Lively says it exactly matches what she said happened. And Team Baldoni says, clearly this is not sexual harassment. It doesn't match anything about what she said happened. And it's the same video. So do check that out. This is going to be part of the story going forward, especially as Justin Baldoni and his team release more public information if they choose to do so. Is that question of, even if we've got a video or other proof in front of us, do the sides agree as to what happened? There are the strikes that we've talked about. Then on January 4th, 2024, this is the date on which the original complaint and New York Times articles start their story. There's an in-person meeting with Baldoni, Heath, producer Alex Sachs, producer Todd Black, Sony executive Ange Giannetti, Lively and her husband Ryan Reynolds in attendance. Lively and Baldoni later present different portraits of this meeting. Lively's suit says the parties discussed a list of 20 examples of the behaviors that gave rise to the protections for return of production document. It does say that. This is an interesting aspect of the amended complaint, which we can discuss right now. It says 20, but the list itself is 30. Baldoni in his suit claims Reynolds berated him during the meeting, and that Lively's suit misleadingly suggests the parties agreed to a list of 30 items during this meeting. Many of the items listed in her complaint were entirely new, baseless, and never presented or discussed. So this is an actual fact dispute here, right? One of the things that Lively claims is that this list that she produces in her complaints was discussed in its entirety and agreed to by all parties. Baldoni says, no, it wasn't. This was not discussed in its entirety, and reasonable minds, reasonable memories can differ on this particular score as to whether Blake Lively said this entire list out loud, paraphrased some of it, whether Baldoni didn't hear all of it. If it wasn't presented in a contract, if it wasn't presented in writing and was just read to them, who can say whether or not the whole list was read or what you remember? But that's an area of dispute right here, and certainly the fact that she lists 20 in her legal document is interesting because there are multiple pages that do have 30 listed items on them. Then we have the Lively cut versus the Baldoni cut. There are dueling narratives on what happens during post-production. Baldoni alleges that Lively demanded access to the editing room, ultimately working on her own cut if it ends with us, after threatening to not promote the movie otherwise. Faced with Lively's escalating threats, ranging from potentially delaying the film's release to outright refusing to promote it, Wayfarer once again reluctantly conceded to her demands, allowing her to continue editing with her personal editor. And again, they're going to claim extortion here, but Wayfarer once again reluctantly conceded is that t-shirt I talked about earlier in the series. You could make a t-shirt of, nevertheless, we relented to Blake Lively, and that is in and of itself extortative. Lively maintains that Baldoni's claims that Lively bullied her way into the edit room are false, and we can easily see how this can be just a difference in perspectives. What is undisputed? Lively works with her own editors, including a veteran of Reynolds' Deadpool and Wolverine, on a cut that Sony ultimately allows her to take to Book Bonanza on June 14th, 2024. Her suit states, as amended, the Sony cut is the film that was chosen to be released in theaters. There's no dispute there. Ms. Lively led the Sony cut with their support, working in close collaboration with Sony and Colleen Hoover. Again, Sony is the mystery box in the room. We don't know where Sony lands on these things. The fact that Baldoni doesn't really reference Sony as a bad actor here is suggestive of the fact that Sony was backing Blake Lively as part of this initiative. That doesn't mean that Lively didn't essentially extort a movie out of Wayfarer and Baldoni with the help of Sony. That would just make Sony complicit in that extortion if it looked that way. But it does mean that Lively has at least a hook to hang her hat on, which is to say Sony was backing her editing this cut of the movie. We knew that because that's the movie that got distributed. Then we have the two premieres, the dueling premieres, or the basement premiere, however you want to think about this. It ends with us premieres in New York, where Baldoni does not take photos with the rest of the cast. According to his suit and supporting documents, like photos, he and Wayfarer were asked to throw a separate party and were kept from interacting with Lively and the rest of the team. Baldoni calls this a humiliating culmination of his years of work on the project. Again, note Hollywood Reporter being as neutral as possible in this particular case, saying Baldoni calls this humiliating. I don't think there's any question that to the extent you're asked to throw a separate party and you're paying for both, it is in fact a humiliating culmination of your years of work. But he claims it, suggests that a reasonable mind, somebody else, might not find it so. Following weeks of speculation on TikTok of a rift between Lively and Baldoni due to their lack of joint press events and photos together, The Hollywood Reporter reports on the feud between Lively and Baldoni, though its scope is not yet public. Still, It Ends With Us becomes a bona fide hit when it launches August 9th, opening to a much better than expected $50 million, on its way to $351 million globally. Yes, it is a hit. That's a part of this story as well, right? People ask me, are either of these folks going to work in Hollywood again? I do think part of the story is they made a lot of money on a very little investment. Chances are Hollywood is going to look past a lot of stuff in order to see if they can make more money on another little investment in the future. Doesn't mean it's necessarily going to happen, but it does mean that money solves a lot of problems. And if customers are willing to go and pay for tickets to the next Blake Lively movie, then Blake Lively is probably going to have a career. I don't know about Justin Baldoni and his direction. I haven't seen this movie. People in the comments can let me know. But is there anything special about the direction, or could anybody have directed it in the way that he did? I can't speak to that. Then public sentiment turns against Lively. August 2024. In the weeks after the film's release, the public sentiment turns on Lively as some accuse her of not taking the film's domestic violence subject matter seriously during the press tour. Lively claims in her suit that Baldoni and his team, including veteran PR crisis manager Melissa Nathan, formulated a retaliatory plan to smear the actress, including by hiring mysterious figure Jed Wallace. Oh yes, Jed Wallace, the one that the New York Times couldn't even pin down on what he might have done. She also accuses Baldoni of not sticking to the previously approved marketing plan. Baldoni maintains that the plan was defensive to Reynolds and Lively's ongoing threats, and that any public sentiment turn against Lively was organic. Then Lively goes public, December 21st, 2024. Enter Hangouts and Headlines. Lively files a complaint accusing Baldoni of sexual harassment, creating a hostile work environment, and orchestrating a campaign to smear her. The bombshell coverage from the New York Times sends ripples throughout Hollywood. Wayfarer and Baldoni's public relations representatives, Melissa Nathan and Jennifer Abel, are also named in the complaint, which includes dozens of emails and text exchanges as evidence for her claims that his team engaged in a social manipulation campaign to destroy her reputation. Now, this is probably too pat. This is not going in depth enough based on what we know of these documents regarding what was in this complaint, or that the New York Times covered this complaint, which wasn't otherwise generally known to have been filed, the day after its filing, suggesting a fairly close relationship between the parties on that particular story. Lively later formally files a lawsuit on December 31st, 2024. That same day, Baldoni files a suit against the New York Times for libel, accusing the newspaper of conspiring with Lively's public relations team to advance an unverified and self-serving narrative, using cherry-picked and altered communication stripped of necessary context while ignoring evidence that contradicted her claims. And the amended complaint does have a response to whether that lack of emoji was cherry-picked. I'm not sure it's a good response, but you can get excited to see that in just a minute. Then we have Baldoni suing everybody else. As the legal showdown escalates, Baldoni files a $400 million suit against Lively, Reynolds, and Leslie Sloan. You can see me discuss that over the course of a couple videos on this playlist. There was a hearing in a legal battle on February 3rd, 2025 about Brian Friedman. Clearly, at bare minimum, Brian Friedman, Justin Baldoni's lawyer on this, has irritated Team Lively / Team Reynolds to a great degree. Brian Friedman, the Baldoni attorney who is also a skilled media operator, as you really should be if you're an attorney, goes head-to-head in a New York City courtroom with Lively's attorneys over how much he can share with the press. One federal court rule bars lawyers from making statements to the press that could prejudice a case. Now, in general, you can't make statements to prejudice a case. That's true, and federal courts have general rules on that. What is being used in this particular case is not a federal court rule. It is a order of the court that adopts a code of ethics that is part of what keeps you barred, licensed to practice law in these various jurisdictions. We're going to look at that in just a second. U.S. District Judge Lewis Lyman adopts the rule as an order of the court with some reluctance, as he does not want the case to devolve into satellite litigation over statements made by the attorneys, right? You can easily see if you've got two media operator type attorneys arguing on the courthouse steps that it becomes a fight between those attorneys rather than the substance of sexual harassment, which is an important thing to tamp down on, and or retaliation and extortion to some extent. Again, Justin Baldoni's arguments, not as strong. He's fighting a PR war somewhat defensively as part of his countersuits. A trial date is set for March 2026. But let's see exactly what order was made. So this is Judge Lewis Lyman looking at this particular case, probably already regretting his decision to become a judge. By consent of the parties, Rule 3.6 of the New York Rules of Professional Conduct is adopted as an order of the court applicable to all counsel of record. Now understand, the rules of ethics in whatever jurisdiction you are appearing in already apply to you. So the court doesn't need to do this. This effectively does almost nothing other than bring in a breach rule under the federal rules of civil procedure if you were to breach it now. So it's adding a kind of penalty phase if that were to happen. But ultimately, the reason there's reluctance from the court to do this is because it doesn't mean anything. But also note that the base of it is the New York Rules of Professional Conduct, which fortunately we can read. So let's take a look at Rule 3.6, trial publicity. A lawyer who is participating in or has participated in a criminal or civil matter, we're looking at a civil matter here, nobody's going to jail for any of this, shall not make an extrajudicial statement outside of court that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Lawyers, we like our words, right? A lawyer won't go out to the press with stuff that will have the likelihood of prejudicing a trial. A statement ordinarily is likely to prejudice a trial if it relates to the character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation or witness, or the identity of a witness or the expected testimony of a party or witness. You can't pre-try your trial out in the public. In a criminal matter that could result in incarceration, that's not us, the performance or results of any examination or test, or the refusal or failure of a person to submit an examination or test, or the identity or nature of physical evidence expected to be presented. Again, our trial works because we have rules of evidence as to what people can see. So you're not going to avoid all those rules of evidence of what people can see by going out there and presenting it on the courthouse steps so that the New York Times can cover it and any juror in the future could have knowledge of that evidence when they get into the courtroom. This is probably one of the areas in which Team Lively is most upset about what Brian Freeman is doing. Any opinion as to the guilt or innocence of a defendant. Information the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial. Again, you can't go around those rules. The fact that a defendant has been charged with a crime unless there is included therein a statement explaining that the charge is merely an accusation and that the defendant is presumed innocent until and unless proven guilty. Now, this is one of those areas of the ethics rules that probably is violative of the First Amendment. We've talked about this a little bit in the context of virtual legality on this channel, but a lot of these ethics rules are probably pretty close, if not over the line, of preventing free expression in the United States. But the legal system says it's important enough that we get this right, that we can press upon lawyers and their ability to freely express themselves a little bit more than maybe the average person. Provided that the statement complies with paragraph A, a lawyer may state the following without elaboration. The claim, information contained in the public record, that an investigation of a matter is in progress, etc., etc., etc. So we have these various rules, and one of the reasons why you see things like the display of Exhibit A on a separate website, that timeline of events and text messages and emails that Team Baldoni put forward, is that Brian Freeman would like to talk about that timeline in a way that is already on the public record. So that exhibit isn't necessary for their complaint. That exhibit isn't necessary for making their legal claims, but it is helpful to get it in the public record for the trying of the case in the media, right? So even if you agree with Justin Baldoni, it might be that you find all of what Brian Freeman and Justin Baldoni's counsel is doing to be, again, legal terminology here, icky, that you don't love the trying of a case like this in the public eye. I don't blame you if you don't. And again, when we've got something of such high sensitivity as sexual harassment, the Me Too movement, all of these things that have been in the public's eye for so long, so recently, I don't blame anybody for saying Brian Freeman is going about it the wrong way, but I also don't blame anybody for saying, look, Justin Baldoni is being put upon. He's in the right on this. He needs to attack these things with as much gusto as he can muster. And so I understand these fairly novel approaches to a case like this one. I think either side can be defended, It's really going to come down to your own temperament and how you would like to see lawyers operate professionally. I don't think Brian Freeman has violated any ethical rules. I will say that right now. I haven't seen that. I don't think the presence of Exhibit A or the timeline is a violation of ethics rules. I think it's aggressive. I don't think we've seen it in most cases, but I don't think it's a violation of the ethics rules. I don't think it should be a violation of the ethics rules. And I think Blake Lively and her team are responding overly aggressive to this particular stance. But that's my opinion. It doesn't have to be yours. So let me know in the comments to this video. Let me know in the chat if you have any different opinion on this. I did see a starred message come through, which I want to grab before we move on from here. But that is Rule 3.6. This is formally ordered by the court to be followed by all the attorneys in this particular case because he doesn't want the attorneys fighting over everything in the trial on those courthouse steps. Oh, it's from my dad. Hey, Thomas Hoeg, how's Florida treating you? I do love this topic. Who else but your members would bring up Rashomon and you were right about whose film it is? We all do see things from a different perspective. Well, who else, in answer to your question, Dad, is The Hollywood Reporter. But again, The Hollywood Reporter, to its credit, likes to reference its stories by reference to other movies. So Rashomon's a good pull for that. We all do see things from a different perspective. Eyewitness testimony is unreliable. There's no question about that. And it is unreliable. There's various aspects of the legal practice that have changed over the course of a number of years. One is unreliable eyewitness testimony. One is requirements from jury members at a higher level of things that we might call CSI type evidence, right? CSI, the very popular television show that had scientists go in and solve crimes more efficiently than we had seen in other contexts. And there were studies done and there were reports done about how juries tend to require more of that kind of definitive proof than we have required in the past, and that essentially a reasonable doubt is not the same standard now in 2025 as it might have been back in 1955 or whatever year you want to pluck out of the historical record. And that's an important part of these stories as well. But thank you so much for the super chat, Dad. I really appreciate your support. I hope you are getting some fun in the sun. It is certainly not fun in the sun here in Michigan. You are not missing anything weather-wise. All right. Thank you, Dad. And that's our super chat. And that's our rule of trial publicity. And now we can go back to our timeline. So Hollywood Reporter misstates this slightly. Again, I think media would be wise to have at least a limited legal analysis capability for when you're going to talk about laws and lawsuits so that you just avoid some of this. But it's understandable and it doesn't really change the substance of their story. Then, as we will see in the amended complaint, Blake Lively is going to reference a woman or a woman, another woman, again, a couple of times in the amended complaint because she doesn't want to use their names. The Hollywood Reporter doesn't care about otherwise sharing these names. In that amended complaint, Lively says 2 actresses are willing to testify on her behalf. Sources tell THR that those actresses are Jenny Slate and Isabella Ferrer. And again, I haven't seen this movie. I do recognize Isabella Ferrer's name as the young Blake Lively character, because there was discussions about whether intimacy happened with respect to Blake Lively before the break for the strike in the complaints, and the only one that had any kind of level of intimacy at all was Isabella Ferrer, at least as stated by Baldoni in his lawsuit. Sources is an interesting question here. Is this Team Lively that's disclosing this to the Hollywood Reporter? You wouldn't think so insofar as they are against what the Hollywood Reporter article package already says, so maybe they are getting that information directly from Jenny Slate and Isabella Ferrer. We don't know. But it's important to note that Blake Lively was trying to not use their names for reasons we'll discuss when we look at the complaint itself, but that was never going to survive contact with the Hollywood media. So it always seems a bit of a fruitful endeavor as we look at these documents, which is all a nice prelude for an amended complaint, which should be nice and very limited. Oh no, it's 141 pages, everybody. Oh my goodness. Well, it's 141 pages. We'll get there. Let's see who's being sued. Blake Lively is still the only plaintiff. That's important, right? Because one of the aspects of this that we've already seen discussed in the Hollywood Reporter is that 2 more women are going to allege to have their own complaints. We saw Jenny Slate's complaint as described by a different Hollywood Reporter article as being maybe not the most sexually harassing complaint that one can imagine, certainly not pervasive or anything that would feed into a hostile workplace complaint. But Blake Lively is still the plaintiff. She's the only plaintiff. And we see Jed Wallace, the infamous, shady, questionable, mysterious, whatever word you want to use, Jed Wallace, included now on the defendant's list. Apparently, Blake Lively and her team think they have enough to actually bring him on as a defendant. It'll be very interesting to see what they have on him because as it stands so far, The complaint that was filed in California, on which the original lawsuit was based, basically said, and Jed Wallace was there, and didn't have any other understanding of what he did. And so that's going to be an important part about what we talk about now. This is 141 pages. I am definitely not going to survive a line-by-line read-through of this 141-page document here with you right now. So what I have decided to do as part of this video, in order to get as much of the best information as possible to you all in Hangouts and Headlines as I thought I could, is to do a kind of high-level 30,000-foot overview of what I see. That's going to include a kind of line-by-line read-through of the introduction, skipping ahead into a lot of different sections of the lawsuit, and then ultimately finishing off with looking at the counts, the actual legal complaints that they make, and the laws that reflect upon them as part of our discussion. And that's what we're going to do with this document. I think there are line-by-line readings from some of my colleagues on YouTube. Please go check them out. I'm sorry that I can't do all of that every time for you, but I have to try to manage my time and energy levels and get you as much as I possibly can in the best way that I can do it. So they've included a table of contents for us now so that we can better know where it is that they're claiming these various things, but it isn't terribly useful to a read through. So we're going to just start where they start with the introduction, where we note Jed Wallace and his company Street Relations Inc. are part of this lawsuit now, and they now start with a quote. Much like your favorite 8th grade speech maker asking to say what a definition is at the start of their speech, this is a technique done in lawsuits essentially that are likely to be facing the media and public relations. It has no legal impact on anything, but we'll see how they use this as the skeleton outline for what they want to talk about here. Are you confident enough to listen to the women in your life, to hear their ideas and their solutions, to hold their anguish and actually believe them, even if what they're saying is against you? And will you actually stand up and do something so that one day we don't have to live in a world where a woman has to risk everything and come forward to say the words, "Me too"? Justin Baldoni, Why I'm Done Trying to Be Man Enough, 2017. So they use a Justin Baldoni quote at the top of their lawsuit where he says that we have to listen to women, stand up for women, and part of what they're trying to do here is to establish that he's a hypocrite, he's a bad guy. Again, most of what you see in the introduction section and early stages of a lawsuit like this one are setting up where the good guys, they're the bad guys. Just remember that as you read everything else. And so this quote is trying to highlight that and put that into perspective for you. I think it's probably a little bit too poetic for my liking. This is not how I would draft this, but this is a very strong document. Clearly, both sides have good lawyers. They have good lawyers that are able to use rhetoric to try to paint the picture of what evidence they have in the strongest possible way for their clients. I am not going to sit here and tell you that Blake Lively doesn't have good legal representation. It is clear that she does. Plaintiff Blake Lively brings this lawsuit because she was unlawfully retaliated against for coming forward and reporting sexual harassment that occurred against her and others on the set of It Ends With Us. Defendant Wayfarer Studios is the owner of the film. Defendant Justin Baldoni is the co-chairman and co-founder of Wayfarer and also served as director, executive producer, and actor in the lead role of Ryle Kincaid. Ms. Lively played the leading role of Lily Bloom. At all times during the production, editing, and promotion of the film, Mr. Baldoni was Miss Lively's boss. Now, that's a normal sentence for setting up the relationship between the parties. I'm not sure, as alleged by Baldoni, it's actually accurate in this particular context. I'm not sure that Mr. Baldoni was Ms. Lively's boss towards the end of promotion of the film, right? At least as described by him. For years prior to the release of the film, Mr. Baldoni portrayed himself as a leader of the male feminist movement. In reality, however, Mr. Baldoni's public persona is a stark contrast to his private behavior, which is replete with hypocrisy, misogyny, and retaliation. Now, in fairness, you don't really have to say he's a hypocrite as part of what is the problem with him. Generally speaking, you describe the actions that make him a hypocrite. In public, Mr. Baldoni gave the appearance of taking responsibility for the fact that he had unconsciously been hurting and silencing the women in his life, and implored men to be man enough to shut the hell up and listen to women. He claimed that he wanted to end toxic masculinity, acknowledging his own toxic behavior by admitting that there is a woman or two that I, in some way, made uncomfortable by saying something or doing something that was chauvinistic or sexist. There is 1,000,000% probability that that exists, and that he wanted to say he was sorry and would do better. Mr. Baldoni echoed this narrative while marketing the film. In an interview on CBS discussing the release of the film on August 7th, 2024, he claimed, "I want men to stop asking the question, why do women stay? I want men to take accountability. I want men to hold other men accountable." Now, we can see what they're trying to do here. They're painting that hypocritical nature of him in what he said before and what they're going to claim he did on the set of It Ends With Us. But I have to say on a separate note that I don't think as a legal perspective, as a legal matter, we actually want to disadvantage men who are out there saying these particular types of things in a legal liability sense, right? We don't want there to be some kind of moat built around saying, I did some bad things in the past, or I think it's important for men to stand up for women. We don't want that to be used as a cudgel against you in a lawsuit, because otherwise men are not going to do that. And we want there to be more equality. We want there to be more comfort on the set of a movie like this one in workplaces that are not movie sets. And I look at this and say, this is bad insofar as we allow this to be the stance that somebody takes in a case like this one, because we are trying to penalize what appears to be fairly open communication from this individual. At his own moment of truth, when forced to confront women he had made uncomfortable on his own set, and note the use of the word uncomfortable, right? They're trying to pin this to that quote up here. There is a woman or two that I in some way made uncomfortable. That's not an admission of legal liability. Discomfort is not the standard for sexual harassment. It is not the standard for a hostile workplace. He trivialized their concerns and failed to take accountability for the effects of his behavior, whether intended or not. Well, intent does matter on this particular score. And when faced with the predictable consequences of having created a toxic set, namely that the cast did not want to appear alongside him in public rather than holding himself accountable, Mr. Baldoni hid behind his billionaire friend and retained publicists, crisis managers, digital media strategists, and litigators to mount a sophisticated and well-funded retaliation campaign that sought to bury and destroy anyone that challenged his brand. That campaign has succeeded beyond Mr. Baldoni's wildest expectations. In fact, the defendant's actions have created such a toxic climate of online vitriol against Ms. Lively, her family, other members of the cast, and various fact witnesses that all of the above have received disturbing threats. So a couple of points on this particular one. One, if you are claiming that they are retaliating against you for bringing a sexual harassment report, you are going to have to focus your retaliation campaign on you. I know that it can seem advantageous to say, look at how effective it's been against all these different people, but that actually hurts your claim here, because if there's just an overall negativity about the movie, about the cast, about the set, about whatever, then that isn't a retaliation campaign against you individually. And on a more practical basis, one of the defenses that Team Baldoni has already brought up is, why would I do this to my own movie? This is where we make money from. It already looks like it's a dumb idea for me to have a retaliation campaign in the public on this score. Why would I hit everybody related to the movie if I'm only trying to hit you? One fact witness known to publicly support Ms. Lively recently received a written threat indicating that the witness's family would be sexually assaulted and killed unless the witness agreed to make a statement and give the truth. Now here again, I wanted to add this other point, which is to say, look, online sucks. All right, I love you guys in the comments. I love you guys that are listening or watching this later on. But so much of the internet is unhinged. I receive death threats. I receive threats for the things I say here. I am definitely not Blake Lively. I'm definitely not Ryan Reynolds. I definitely don't have their clout or power or authority. And I receive those things. I'm also not, I don't believe, the target of a malicious PR campaign of some kind. I think people are organically coming to the conclusion that I need to die or otherwise be harmed. And that's not great. I don't love that about them, but that is their right to do in very important respects. And so I look at these things and say, this is designed to be read by a court that maybe doesn't have that same kind of acknowledgement or understanding of what online interaction and being in the public eye in 2025 is actually like. That's not fair for anyone. I would see the law be more carefully curated against that type of behavior, but I also am very much a fan of free expression, so I understand it's a difficult line for the law to draw, but framing it in this way, like it must be the case that you get these particular threats because the other side engaged in some kind of retaliatory PR campaign, doesn't hold water to me. And if the court or the judge in question here has any understanding of how online environments work, I don't think it will hold water for them. This type of climate was the predictable, if not inevitable, result of the retaliatory campaign launched by the Baldoni Wayfarer parties, both before and after the litigation began. And one of the aspects of this introduction that I wanted to point out to you all is that there is an aspect of this that really reads to me as Team Lively, and I'm going to say Team Lively, even though I think it's really Blake Lively at its core, instructing her lawyers as to what to say here, does not acknowledge that there is any possibility that negative PR could have happened organically. That somebody could just not like you, right? And people don't like me. There are a lot of people that don't like me. There are a lot of people that do like me. There are a lot of people that do like Blake Lively. But some people are not going to like you, especially if you put yourself out in the public eye. And there is an abject obsession with refusing that as even the concept of a possibility here. And one of the things that they're really going to struggle with as we look at this introduction and on in this document is the notion that this campaign actually happened. They're going to use a lot of people talking around that they could have engaged in a campaign. A lot of people saying, yes, I definitely did this, pay me my money, all these various other aspects of conversations around the campaign. They are not going to use this amended complaint to actually put forth evidence or even assertions that the campaign actually happened. They're going to do it all by intimation, and that's going to be a problem for them. The other problem for them is what I call the trust me bro paragraph, which reads as follows. The dangerous climate of threats, harassment, and intimidation fueled by the defendant's retaliation campaign has required Ms. Lively to alter her personal and professional life, not to miss the Saturday Night Live event though, and to take steps to prevent innocent bystanders rather than exposing them to further harm. Thus, this amended complaint does not refer to certain witnesses by name, nor does it provide screenshots of their text messages. Importantly, however, these witnesses have given Ms. Lively permission to share the substance of their communications in this amended complaint as contained herein, and they will testify and produce responsive documents in the discovery process. Equally importantly, I would argue, is that they did not decide to join as plaintiffs on this particular case. They are not willing to stand publicly for this particular proposition that you've presented in this document. So we're going to refer to them in this way. We have this evidence. Trust me, bro. But we're not going to tell you the names, which is a really, really odd paragraph, right? I try to identify areas in which there are oddities here on the understanding that you're not reading lawsuits maybe as often as I potentially am or as others in the legal sphere are. And so this is a paragraph that is really strange. So they premise this as there is a retaliation campaign. There are threats everywhere. Because of those threats, we're not going to go through the difficult work of actually establishing our allegations. We are just going to say, trust me, another woman said this, another woman said this. And then when it's reported on by the Hollywood Reporter as they got $15,000 or rejected $15,000, it's a little unclear there in that story. They were unhappy because they were called mother too much. The story is entirely unclear in the Hollywood Reporter. It's not going to be covered here in this amended complaint, so you don't have to worry about that. But that's the paragraph. This to me is the death knell. I got to this part, paragraph 6, page 6 of the amended complaint and said, uh-oh, I'm not sure you have much of anything here. You're trying to tell us that you have all this other evidence, but you're not going to tell us exactly how it comes from. You're going to cover it up with things that you can say on your own. That's going to be a problem for actually making this particular case. And remember from earlier videos in the series, in order to make a retaliation complaint, they have to establish that there either was sexual harassment or a hostile workplace environment, or that Ms. Lively thought that there was, and she reported it. And then retaliation happened as a result of that reporting. And then there's a whole bunch of other stuff that we've talked about in other videos about the retaliation having to be an adverse employment event. But separating that out just for a second, she's got a problem because she is having difficulty establishing that the sexual harassment in the first instance actually happened. That's step one of a multi-step process to get to the end state where she wants to win for retaliation. So this is a weak legal claim. It's weaker by this paragraph, and this is the last bite at the apple, or likely last bite at the apple, of actually making this case to begin with. Both sides are going to seek as next steps or in the immediate future to have the other side's case dismissed. And they're going to say, look, judge, court, if you read this exactly as true, you assume everything they say is exactly as they say it, they have not stated a claim of legal action that this court can actually correct for. And I think that Justin Baldoni and his team is going to have the ability to say, they've asked us to trust them on all of these things. That is not the job of the federal court. We do not have to trust them. They got 2 cracks at this. They were unsuccessful in actually stating the things that they need to say in order to make this effective in court, and you should get rid of it. Do I think the court will get rid of it? I do not. I think courts are very reluctant to issue summary dismissal on cases like this one, but that is what's going to happen in both cases. And I think this amended complaint, being as weak as it is, as we will see, is going to be the death knell for certain parts of Lively's campaign in public relations on this particular point. It certainly is with me. After seeing this document, I looked at Ms. Lively's original complaint again. I looked at the New York Times article, and I think, at best, being most generous to Blake Lively and Ryan Reynolds and her team, there was discomfort, and she decided to elevate that discomfort, maybe to take over the movie, maybe for other reasons, maybe ego, maybe otherwise, into the case of a federal court. And I don't think it is the kind of thing that a federal court generally has the ability to provide recompense for. Ms. Lively brought this lawsuit because she was one of the women or two that Mr. Baldoni 1,000,000% made uncomfortable on the set of the film. And again, they're trying to tag that to the quote right? Which is a nice rhetorical device. Unfortunately, it's a terrible legal device because discomfort, not the standard for establishing a hostile workplace. But Ms. Lively was not the only one who was uncomfortable on set, and Mr. Baldoni and Wayfarer knew it. Okay, tell me more. After Mr. Baldoni learned that he had caused Ms. Lively and others to feel uncomfortable, he turned his TED Talk and feminist advocacy on its head. He did not hold himself and other men accountable, or take his own advice to be confident enough to hold their anguish and actually believe them, but instead used a louder voice to silence Ms. Lively and anyone else who might speak up. That louder voice, amplified by publicists, crisis managers, digital media teams, and those dirty lawyers, has sought to mislead the public into believing that Ms. Lively did not experience sexual harassment by portraying her as a powerful bully who fabricated claims of misconduct in order to seize control of Mr. Baldoni's movie. Again, I think the seizing of the movie concept is a response to why anybody would do this, to try to add some kind of rationality towards why they think this is overblown. I don't think any of that is necessary to make the case that there wasn't sexual harassment on the Baldoni side. Really, you just have to look at every instance and determine for yourself whether that is harassing conduct, and then whether the overall pyramid of stories that they have given you results in a hostile workplace. This narrative is false and nonsensical on its own terms, says Team Lively, completely at odds with Mr. Baldoni's confession to his crisis manager on August 30th, 2024, that Ms. Lively is the kind of person that genuinely believes she's right and that all of this is unjust. So they're going to do two things with this quote, both of which are wrong. The first is they are using this to suggest that Mr. Baldoni thinks that this is actually unjust. They separate out that Ms. Lively is the kind of person that genuinely believes she's right from that all of this is unjust. They're going to use that in a couple of places in this document to suggest that he's confessing that he understands that all of this, the retaliation campaign that they are suggesting happened, is unjust. When the better way to read the sentence, in my opinion, is that he's saying that this kind of person believes they're right and believes that this is unjust. That the kind of person genuinely believes applies to both the rightness and the unjustness. They're going to separate those things. But also, they're trying to say that she believes these things as a point of law, that she feels that she was sexually harassed. I think that's different from what the quote actually says. And again, we're not going to have necessarily an objective standard apply to all of this, which is a reasonable person standard, but we are going to be able to look at this and say, okay, she's somebody that feels aggrieved. She's someone that feels aggrieved easily. She's someone that kind of believes that that grievance is something that should be adjudicated in some form or fashion. I think you can say that, and it's not a confession when you make that to your crisis manager. She really thinks these things. She's dangerous is what I'm trying to communicate there, because somebody that really believes these things is more dangerous. But it doesn't mean that she believes that she was actually sexually harassed. She just believes that she was put in an uncomfortable position. She believes that she wasn't given the creative control that she should have had. There's any number of ways that you can read this that are not a confession of sexual harassment. And the lawyers are doing their jobs, folks. The lawyers are putting rhetoric out there to try to convince you of these various things. I try to point out when I see a quote or a sentence that I think goes a little bit further than is actually the reality of the situation. This is one of those cases. And the reason I point it out here is not just because of its appearance in this paragraph, but because they will use it later on. It's also breathtakingly cynical, according to Ms. Lively, coming from a man whose public brand is built upon a pro-feminist facade that urges others to listen to and believe women. More importantly, the defendant's false narrative crumbles under the indisputable truth that Ms. Lively was not alone in complaining about Mr. Baldoni, and raised her concerns contemporaneously as they arose in 2023, not in connection with some imagined power play for control of the film in 2024. Again, if you're imagining Blake Lively as a Machiavellian power broker, it's not so crazy to think that she would have set up things in 2023 to take place in 2024. We're not talking about a decades-long plan here. But it's also noteworthy to say, if you're going to use the fact there are other women complaining about these things, you're going to probably have to produce some of that evidence, and you're refusing to do so. Mr. Baldoni acknowledged the complaints in writing at the time. He knew that women other than Ms. Lively were also uncomfortable, there's that word again, and had complained about his behavior. On May 24th, 2023, Ms. Lively confided in a text to a woman who is a mutual friend of Mr. Baldoni and Ms. Heath, and we'll see this in this paragraph and elsewhere in this document. So because they are refusing to produce any other evidence from any of the other women they claim are absolutely going to make these statements against Mr. Baldoni, they use Blake Lively's text messages and messages as half of a conversation to establish their complaint. I was going to invite you to set tomorrow. These people, whoa, it's like HR nuts today, the both of them. I wasn't expecting that turn. I mean, it's been present, but today I came home and cried. Further in the exchange, Ms. Lively describes Mr. Baldoni and Mr. Heath as creeps, like keep your hormones to yourselves. This is not mine. I don't want it. I don't want your gaze or words or tongue or videos of your naked wife. Yeah, it's shocking. Clowns. And we can go through all of those various stories. It very well may be the case that Ms. Lively felt like she was being harassed, but there is a standard that we have to look at about whether or not another person, a reasonable person in the same situation, would feel that she was harassed. A few days later, on May 26, 2023, Ms. Lively reported her concerns regarding unwelcome and inappropriate behavior. Okay, where did she report them? To Sony employee Ange Giannetti, the film's representative for its distributor, Sony Pictures Entertainment. Again, Sony basically washing its hands of all this, not otherwise stepping into the fray in any cognizable way that I have seen online. And so reporting it to Ange Giannetti, the Sony rep, person observing things for the people with the money, may or may not be sufficient for an HR complaint under the law. Over the following 3 days in May of 2023, another female cast member, unnamed, reported her own concerns regarding Mr. Baldoni's unwelcome behavior to both Ms. Giannetti and one of the film's producers. Notwithstanding that female cast members' considerable reservations with coming forward, she didn't come forward, she's not coming forward now, she nonetheless spoke up and conveyed her feelings that the work on the film was suffering as a result of Mr. Baldoni's behavior. Now, this is important from a legal perspective because the concept that the work is being impacted by the harassment or the hostility is a part of making a hostile workplace claim. If you can establish this, you've hit a certain standard that harassment was occurring. Ms. Giannetti shared those concerns with Wayfarer. So now they have a pathway, but they don't have a formal one. They have a statement, it sounds like, to Ange Giannetti of Sony, and then Ange Giannetti talking to Wayfarer. We don't know what that looked like in practice. They're trying to establish that reporting was made. On June 1st, 2023, Mr. Baldoni responded to that female cast member. It's very hard to keep track of them when they do it this way. In writing, acknowledging that he was aware of her concerns and that adjustments would be made. Notwithstanding that promise, Wayfarer took no actions to investigate this reported conduct. Now, how would you know that? This is one of those areas where on information and belief is a phrase that we generally use when you couldn't possibly know something. You don't know what Wayfarer did or didn't do to investigate the reported conduct. So they're making this assertion, nor did it implement any protections at that time. They would know those because they would be public protections, presumably. Just 1 week later, on June 8th, 2023, the same female cast member, this is the second woman as listed as female cast member here, told Ms. Lively about her growing concerns with the conditions on set and that she found it difficult to talk to Mr. Baldoni. If you're looking at this and saying, well, all right, now this starts to sound a lot like a hearsay again being designed to prevent us from having to deal with evidence that cannot properly be countered in a court of law. That's not a standard for presenting things in an allegation, a complaint document like this one, but it is worth noting because that makes this evidence inherently weaker than it might otherwise be. This is going to be all based on Ms. Lively responding. So this is the plaintiff herself responding to a complaint that she says existed from another female cast member in June of 2023. She says, I know, I find it really hard to speak to him. I try to cover it with busyness, but not sure that covers what's going on. Later, another female cast member, which actually sounds like a third to me here, confided to Ms. Lively that she too felt uncomfortable on set. Says you. Okay. All of this occurred and was documented in writing almost 1 year before the editing of the film began. Trust me, bro. Before returning to production following the guild strikes based on Wayfarer's complete failure to investigate or address any of the complaints conveyed by Ms. Lively and others, Ms. Lively decided to speak up and require that Sony and Wayfarer agree to a set of protections to ensure a safe set for all of the cast and crew. Thus, in mid-November 2023, the parties agreed to, in writing, to implement a list of protections enumerated in a contract entitled Protections for Return to Production, which included 17 provisions, this is the 17-point document, designed to require Wayfarer to cease the on-set behavior of Mr. Baldoni and Mr. Heath. These provisions were designed to remedy the misconduct that Ms. Lively and others had reported earlier that year. Importantly, none of the requested protections were tied in any way to Ms. Lively's creative input in the film and were made months before any discussions regarding the cut of the film. Now, this is interesting as a paragraph again because they are responding to the notions of extortion that Baldoni has put forth in his lawsuit here, but this isn't actually responsive to their initial claim. This is not something that is part of their allegations, even though this is their amended complaint. This is essentially a preemptive defense. They are saying that they could have asked, if this was all an extortion scheme, they could have asked for creative input right then when we weren't otherwise returning to work, and they didn't. At that moment in time, with the completion of the film uncertain, Ms. Lively did not request, nor did she receive, any creative rights, editing rights, credits, or any other role on the film beyond her roles as an actress and executive producer. In other words, at the precise moment in time when Ms. Lively had maximum leverage prior to resuming production, she did not use that leverage to obtain anything other than protections for herself and others to ensure a safe work environment for all. The notion that she did all of this as some sort of Byzantine plot to take control of the movie at some future point, which she did not do in any event, is absurd, and there is not a shred of evidence to support it. Well, the evidence to support it here is that she did, in fact, make a cut of her own movie, and that cut was what was released by Sony Pictures. You want to use Sony as cover here to say that she was just working on Sony's behalf to make Sony's cut of the movie. That's what you're going to do later on in this document. That's fine. But the actual evidence here is that that's what happened. She did take control of the movie. Justin Baldoni does see it in a basement somewhere, does have a party separate from the rest of the cast, and is ostracized. Maybe because he's a sexual harasser and a bad guy. Maybe because Blake Lively is taking control of the movie and doesn't want to see him and doesn't want to feel guilty about the control that she took. Don't know. We don't know that for sure. This is over-lawyering right here. The shred of evidence to support it is that it happened. So it didn't accidentally happen. Blake Lively didn't accidentally create a cut of It Ends With Us. She did it. And she was given the rights to it, probably by Justin Baldoni. As we saw, he said he was bullied. That's a difficult case to make in law. We've talked about that. But it did, in fact, happen. After receiving the document, Wayfarer responded that Wayfarer, Sony, and production respectfully acknowledge that Ms. Lively has concerns regarding safety, professionalism, and workplace culture. Although our perspective differs in many aspects, that's lawyer for, although we don't agree with any of that, we're still going to do what you ask because it doesn't really cost us anything. Ensuring a safe environment for all is paramount, irrespective of differing viewpoints. Regarding your outlined requests, we find most of them not only reasonable, but also essential for the benefit of all parties involved. Following Wayfarer's agreement, Ms. Janetti texted Ms. Lively on November 29th, 2023, and said, "So glad Todd is in it now and overseeing everything, but wanted to check in, offer anything I can. I know this has been beyond challenging, to say the least. We at Studio want to support you best we can." Sony's on Team Lively. We know this from these various messages. But again, this isn't actually evidence. This is just a response to what Ms. Lively told Ms. Janetti. So we're 3 steps removed from actual primary evidence of what happened at this point. We're going to have to get into the stories that she wants to tell us, which we will see have changed slightly from the original complaint. On January 4th, the meeting that we've all talked about, in which the complaint started with originally, happens, including Ryan Reynolds, who's Ms. Lively chose as her representative. I said it was an odd choice when I first read it. I still think it's an odd choice. A choice which Ms. Lively had the right to exercise under the November agreement. I'm not really arguing that she had the right to, but he doesn't have any particular place in this movie-making process and isn't someone that is otherwise going to be the best advocate of your legal position on things like this. Ms. Lively then read the list below in its entirety. This is the 30-point list. And after a discussion, all parties present agreed that the outlined conduct would cease. If you want to make this claim in the future, you get that in writing. We don't have an agreement in writing. This is all assertions by her as to what happened with respect to this list. I suspect this wasn't written in its wasn't read in its entirety and was instead paraphrased some. And I would expect that moving forward to have the protections agreement signed was saying, okay, yes, fine, we'll sign that protection agreement. But these are the 30 points we've talked about before. These are the ones where you have the no more asking BL to cross physical picket lines, no more retaliatory or abusive behavior, etc. No more being the language they use to kind of make it imply that this behavior was happening before, even though it's not worth Wayfarer or Baldoni's time to really argue the exact wording of a document that they didn't see. So reasonable minds can differ on that, but it does appear to be essentially a legal trap, if nothing else. As the cast and crew returned to production on January 14th, Ms. Lively reassured a female cast member that you don't need to hug anyone this time, which is not in quotes, to which the female cast member responded with gratitude. Ms. Lively continued that he won't touch you or shouldn't. I don't think he or Jamie will. Now, interestingly, again, because this is all framed as the communications from Blake Lively, this sounds, without the other half of the document, that she is putting forth all of these notions, that she's incepting these concepts into these other people, which of course is what she's accused of doing by Baldoni, who says that, like, Ms. Lively and Ms. Ferrer, who we know is one of the named people in the Hollywood Reporter article, were not on set at the same time. Ms. Lively expressed her belief that it would be a professional set and we're getting good work. All of which is fine. None of which adds to the complaint because it's all just Blake Lively again speaking. Then we have the discussion about the marketing plan. In the days leading up to the film's release, Mr. Baldoni abruptly pivoted away from the film's marketing plan. Again, this speaks to me again of Blake Lively being uncomfortable with notions that she was doing a bad job of marketing the movie. This section never really made sense from a legal standpoint outside of the public relations sense, because following the marketing plan or deviating from the market plan is not related to sexual harassment, is not related to retaliation. This is essentially a preemptory defense against what Baldoni says, which is that Blake Lively was bad at this, and the response to her being bad at it was organic. So the response that she was just following the marketing plan doesn't actually answer that. The marketing plan could have been trash. Justin Baldoni could have separated from the marketing plan because he saw that it was trash. And yet Blake Lively is trying to use that as evidence that it wasn't her fault that she was being so poorly received in this particular marketing sense. Other cast members contemporaneously observed Mr. Baldoni's pivot as it was happening. For example, a female cast member lamented to Ms. Lively in a text on August 10th, 2024, that Mr. Baldoni's marketing pivot was jeopardizing the success of the film, and opined that the pivot would not work because it would eventually come out that Mr. Baldoni was using domestic violence commentary to cover his own behavior. Now, evidently, it did work to market the film. Whether or not it covered up anything is going to be a reasonable minds can differ kind of standpoint. What the public also did not know was that this was the beginning of a multi-tiered plan that Mr. Baldoni and his team described as social manipulation designed to destroy Ms. Lively's reputation. That plan was backed by virtually unlimited resources. Wayfarer's co-founder, co-chairman, and leading financier is multi-billionaire Steve Sarowitz, who divulged to a witness at the film's New York premiere on August 6, 2024, that he was prepared to spend $100 million to ruin the lives of Ms. Lively and her family. Now, you wouldn't usually put that in writing. What did he actually say? Let's look at footnote 8. What is footnote 8? When asked about this comment, Mr. Sarowitz's counsel confirmed that his client is prepared to spend whatever necessary to defend Baldoni, Wayfarer Studios, and himself. Well, that's a very different quote from counsel. This is a weird paragraph, guys. Did he actually say that? He wanted to ruin the lives of Ms. Lively and her family? It seems like this is the place that you would put it in your legal document, and maybe the comments to this video will have some instance of social media finding out what the actual quote was and can add it to the conversation. But from a legal document perspective, this is where you would put that. Certainly that's very different from the notion that his counsel put forth that he's willing to spend what it takes to defend himself and Baldoni and Wayfarer. This was not the only time Mr. Sarowitz made such a threat. On an unrelated project, if Ms. Lively or Mr. Reynolds ever cross the line ever, then I will go after them. And that raises the question of what the line is in that particular context. He declared, I will protect the studio like Israel protected itself from Hamas. Thanks, YouTube. Not making any stances on the war in the Middle East. Thanks. There were 39,000 dead bodies. There will be 2 dead bodies when I'm done. Minimum. Not dead, but you're dead to me. So that kind of dead. But dead to a lot of people. If they ever get me to that point, then I'll make it worth their while. Because I'm going to spend a lot of money to make sure the studio is protected. Okay, so that's the quote you mean to ruin their lives. They'll be dead to a lot of people. Okay. Supported by Mr. Sarowitz's financial backing and militaristic worldview by using Israel and Hamas. Okay. Then we're going to get to that paragraph in just a minute. But obviously, this is not a great quote for Team Baldoni. This does look like a billionaire who is very aggressive with his money and says, look, I'm going to protect everybody and they're going to be dead to you when I'm done with them. So that's a useful bit of evidence here, but it's, again, not strong enough to establish that this retaliation campaign actually took place. What we are going to see as a pattern in this document is quotes like that one that admittedly look bad. They look very much like Johnny Depp slamming cabinets in his kitchen, that look bad and want you to infer everything from that bad look, but they don't appear to have the core of the matter, which is that this bad thing, this retaliatory campaign actually took place. On July 31st, 2024, following the recommendation of their publicist, Jennifer Abel, Wayfarer and Mr. Baldoni retained a crisis communications specialist named Melissa Nathan and her company, the agency group PR, TAG. Ms. Nathan delivered a proposal for a bunch of things, including starting threads of theories. And importantly, and I highlighted this in pink because this is an important part of their entire thesis of the case, all of this will be importantly untraceable. So they're trying to tell the court, and I didn't understand why these quotes were included before. That's why they're using bold and italics here to help us out to understand what they're even getting at. They're trying to say, because it's untraceable, we'll never be able to prove it to you. So you have to take all of this kind of circumstantial evidence and look in the area between the coloring and see the retaliation campaign for what it is. This plan went well beyond standard crisis PR. What Ms. Nathan proposed, including a practice known as astroturfing, which has been defined as the practice of publishing opinions and comments on the internet that appear to come from ordinary members of the public, but actually come from a particular company or political group. And so they're saying they're astroturfing, it's all a shadow campaign, and they're prepping you for the notion that we're not going to be able to actually prove this in the way that you would expect something to be proved to you in a court of law. Also importantly, I wanted to capture this footnote 10 about social manipulation, in which they respond to the emoji complaint. And if you haven't been with us in all the videos in this series, the complaint is that when they put forth the text messages that they got from Jennifer Abel's phone, they neglected to include an upside down emoji that made a sarcastic conversation look not sarcastic and use that as part of their complaint. Justin Baldoni says they deliberately eliminated that emoji and thus essentially committed a kind of legal fraud in the filing of that complaint with California and certainly with their conversations with the New York Times. And they say here in footnote 10 that that's not what happened. Ms. Lively obtained the communications set forth in her original complaint through the legal process, including a civil subpoena served on Jonesworks LLC. In statements to the media and in public filings in this court, certain of the defendants and their counsel have baselessly claimed that Ms. Lively or her counsel engaged in criminal alteration of these materials. That is false. At all times, Ms. Lively has understood the produced documents and communications to have been lawfully obtained, maintained, and produced by Jonesworks. Ms. Lively included all excerpts of communications as produced, which on information and belief were produced in the data extractor programs Celebrite, default font and format, including, for example, the absence of text emojis in that production format. Images such as emojis, when available in a preserved screenshot, for example, were attached as produced. So they're saying, look, what we got delivered to us by subpoena did not include that emoji, so it was essentially inadvertent to keep out. It wasn't criminal fraud. It wasn't any of these things that we're accused of. And yet, that is still not a defense of the fact that the conversation completely changes its tone with the inclusion of that emoji. So it is an area where they are essentially yielding the field on that score, at least as it's presented in this footnote, and we'll want to keep track of it going into the future. On August 2nd, 2024, TAG circulated a scenario planning document to Mr. Baldoni and others, which describe preparations and strategies should Ms. Lively and her team make her grievances public. So the highlight here appears to be trying to establish that this is a retaliation campaign because making her grievances public would be something legal that she can do. But it isn't the direct pathway between reporting on sexual harassment or engaging in a legal process and whatever retaliation might be. So this is, again, a half-stolen base from Team Lively here, which is to say, responding to making your grievances public by doing other public relations things is not illegal. It's not obviously retaliation under the legal precedents that we have in front of us. We'll take a look at the law later on in this video, but they're trying to take that base because they're trying to establish that retaliation occurred, and they don't really want to have the fight, it doesn't look like still to me, about whether an actual human resources reporting event happened. Right? They want to say they were retaliating against making this public, and that in and of itself is not what we're talking about when we talk about retaliation. To get ahead of this narrative, Ms. Nathan's plan proposed strategies to advance misleading counter-narratives, including pushing Ms. Nathan's narrative that Ms. Lively had a less than favorable reputation, proposing to explore planting stories about the weaponization of feminism, and misleadingly blaming Ms. Lively for production members' job losses. Initially, Mr. Baldoni expressed concerns that TAG's written plan was insufficiently aggressive to protect him. And I always think this inclusion is odd because they're trying to get to some of the quotes and text messages that the various PR people have amongst themselves in this context. But you're trying to establish that Justin Baldoni is a bad dude. And not only is a bad dude that sexually harasses people on the set of the movies that he controls, but he's such a bad dude that he seeks to destroy them and their families after the fact if they choose to go public or report him to any of the authorities that might otherwise do him harm. But what you present here is that he thinks it's insufficiently aggressive. It's not that he wants to kill anybody. Ms. Abel and Ms. Nathan engaged the following text messages explaining that Mr. Baldoni wants to feel like Ms. Lively can be buried. And that's fine. That's all well and good. And again, these PR people, as we said in the first reading of this complaint, are probably not terribly wise to have these kinds of conversations by text message. We've talked about this before. I think this is a bad look for public relations people. You see that somewhat in the Hollywood Reporter article that we read earlier, but you shouldn't put this kind of conversation down in anything that can be repeated. Ms. Nathan followed this by assuring Ms. Abel, you know we can bury anyone, but I can't write that to him. So she's cognizant of the fact that you can't make these communications to your client, but she's okay writing them to her public relations professional here. And yet you always have to anticipate. I know it sounds stupid, but you always have to anticipate that somehow you're going to find yourself on the wrong end of a Jonesworks subpoena. And those text messages are going to be used against you. And more importantly, for the public relations professional, they're going to be used against you as a professional against prospective future clients, right? When you have all these backroom talks about how your clients are and they're going to be used against you in a lawsuit like this one, other clients are going to have concerns that you're bad-mouthing them to other people and otherwise acting duplicitously. The retaliation campaign relied on more than just publicists and crisis managers spinning stories. They also retained a Texas-based contractor named Jed Wallace. Yes, you added him to the defendants list, so what do you got on him? Who weaponized a digital army around the country from New York to Los Angeles. You're not even putting an information and belief on that, oh? and beyond to create, seed, promote, and engage with content that appeared to be authentic on social media platforms and internet chat forums. The Baldoni Wayfarer team would then feed pieces of this manufactured content to unwitting reporters, helping to make content go viral in order to influence public opinion and thereby cause an organic pile-on. That's an assertion. That is certainly an allegation in this complaint document. Do you have anything at all to back that up? To safeguard against the risk of Ms. Lively ever revealing the truth about Mr. Baldoni, the Baldoni Wayfarer team created, planted, amplified, and boosted content designed to eviscerate Ms. Lively's credibility. They engaged in the same techniques to bolster Mr. Baldoni's credibility and suppress any negative content about him. On August 10th, the day after release of the film, Ms. Nathan's team reported that they had started to see a shift on social, due largely to Jed and his team's efforts to shift the narrative against Ms. Lively. Now, in this particular context, I can see what they're trying to do. I think they're presenting the story better than they did on their first crack in the first version of this complaint. They're trying to say, okay, here's an acknowledgement that Jed Wallace and his team are succeeding in what Jennifer Abel wants them to have done. But in this context, this is the message of a professional trying to establish that the money you just spent on this person I recommended was not wasted. And so there's a lot of examples for why this is not necessarily saying what it is that you think it's saying. When you try to establish the existence of something like a shadow digital retaliation campaign based only on the comments of others talking about it or around it in another context, you're going to have this issue. I think this is inherently weak, even though I think it's better explained what they're trying to establish in this document than it was in the first. That same day, Ms. Nathan noted that as part of this shift, the majority of socials are so pro-Justin, and I don't even agree with half of them. Again, that's designed to say that's because Jed Wallace is feeding everybody lies, and everybody's picking up on those lies, but it's easy enough when you have knowledge of something personally to look at how the internet talks about it and say, well, they're getting it wrong. But that doesn't require a PR campaign, right? Dep v. Heard was a big deal. There were millions of people watching us on Alita's channel, and a lot of people talking about us, and a lot of people surmising what was happening behind the scenes with Alita and the rest of the people that were on that particular stream. And believe me when I say there was a lot of amusement on our behalf as to what you all were thinking was happening with respect to beefs and anger and drama that was 1000% not happening behind the scenes. And that happens whenever you are close to something and the internet gets hold of it. Later in the same text conversation, Ms. Nathan and Ms. Abel described the shift in social media, which they had earlier admitted Mr. Wallace and his team had claimed Mr. Wallace and his team had causing Ms. Abel to conclude that Ms. Lively deserved what was happening on social media because she had unfollowed Mr. Baldoni on social media and declined to do publicity with him. So the story is that they hired Jed Wallace. He's Darth Vader. He's doing all this stuff. They're admitting he's doing this stuff. No, we're not going to put anything in this document to say what it is that he's doing because we have no idea. But again, trust me, bro. Defendants have admitted that on August 12th, 2024, in the midst of a massive sentiment shift on social media that was engulfing Ms. Lively and others with a flood of negative comments, again, why were they attacking others? Wayfarer was asked to issue a statement to help correct the situation by accepting accountability for the production it oversaw. But rather than doing so, Ms. Nathan advised that issuing such a statement would be a career killer for Mr. Baldoni, who she urged to lawyer up and fight. And this is common for public relations documents and common for discussions online, but it is not in any way a legal liability item for you to advise someone that they need a lawyer when there's potential legal liability in play, or for that person to indeed hire a lawyer in that particular context. He's being asked to sign something that could impact his livelihood and career. Go ask a lawyer. Go ask some professionals on this. For that to be used against you, honestly offends me as a lawyer myself. Less than 1 week later, they again bragged about how they had shut down stories regarding HR complaints on set. On August 15th, 2024, Ms. Nathan remarked that this went so well, it was genius. So, okay, we have the four majors standing down on the HR complaint. As their own words reveal, the purpose of this social manipulation plan was twofold. It aimed to conceal the pattern of harassment and other misconduct by Mr. Baldoni, Mr. Heath, and Wayfarer, and retaliate against Ms. Lively by battering her image, harming her business, and causing her and her family severe emotional harm. Millions of people, including many reporters and influencers, who saw these planted stories, social media posts, and other online content, had no idea they were the unwitting consumers of a crisis PR, astroturfing, and digital retaliation campaign created and funded by Mr. Baldoni and Wayfarer to hurt Ms. Lively. So this is now covering the second level of things we can't prove, right? So even if you go and ask the influencers, even if you go and ask Hoeg, even if you go and ask Alita, even if you go and ask the various people on X or otherwise, whether or not they were part of a PR campaign, they didn't know. So Jed Wallace was so secretive that he had his minions do his bidding, and the people that honestly took that up didn't even know they were a part of that campaign. That is precisely the goal of an astroturfing campaign. to light the fire and continue to stoke conversation secretly, blurring the line between authentic and manufactured content and creating viral public takedowns. Okay, you've told us a story, but I'm waiting for you to actually show us the gun. In just days, the retaliation campaign had resulted in the viral spread of hateful, threatening, and derogatory content directed at Ms. Lively, her family, and other female cast members, as well as harassment and cyberbullying of the same. So it is clear that the internet did have its way with the various people involved, and it ends with us. I think they can definitely prove that. But stating that it's a result of a retaliation campaign is still a trust me bro type assertion, because they haven't put forth any evidence of that other than these other comments from Jen Abel and Melissa Nathan. As described further below, many individuals and businesses other than Ms. Lively herself began to experience vitriol, harassment, and cyberbullying around this time, demonstrating the obvious falsity of defendants' self-serving insistence that they engaged in no proactive measures and that this viral spread of online hatred was entirely the result of Ms. Lively's own remarks and actions during the campaign for the film. Indeed, these facts are not in dispute. Mr. Baldoni and the Wayfarer parties have already admitted that Ms. Lively raised concerns multiple times. They admitted that they created a plan in case she made her grievance public, in which they planned to plant stories suggesting Ms. Lively was a bully and weaponizing feminism. They admitted that their team was able to bury anyone. They admitted that they bragged and laughed at how negatively the narrative had shifted against Ms. Lively and how successful they were at confusing people. They admitted that within hours of laying out their plan, they started to see a shift on social due largely to Jed and his team's efforts to shift the narrative. And they did all this despite the knowledge that Ms. Lively genuinely believes she's right and that all of this is unjust. And again, they're trying to hit the all of this is unjust concept as them acknowledging that what they are doing is unjust. That is not what that sentiment means at all. They know it. This is still good lawyering. It's a little bit close to untruthful with the use of the quote that way, but putting this in this paragraph and trying to state what it is that they're showing, look at all the shadows on the wall, there must be a retaliation campaign there, is effective, but I don't think that they've actually established that that campaign exists. Despite all of this, they claim their plan was never implemented, and somehow the universe simply organically provided them with the exact result they planned for, at the exact time they wanted it, using the exact narratives they developed. The problem for defendants is that they put the plan for their untraceable campaign in writing, and the evidence shows them commenting on the success of their plan as it unfolded. In her opening complaint, Ms. Lively noted that she is informed and believes that Mr. Baldoni and his associates have additional astroturfing plans that they have prepared and are ready to launch at a moment's notice. That is precisely what occurred starting the moment that Ms. Lively sent a cease and desist letter to defendants on December 20th, 2024, including with it a copy of her administrative complaint filed with the California Civil Rights Department. Upon receiving the cease and desist letter, defendants leaked, so that's Baldoni leaked, that's the accusation, the administrative complaint to certain handpicked publications to get ahead of it, gave numerous statements to the press, including blatantly false and defamatory factual allegations, and began a near-daily media and social media blitz aimed at discrediting Ms. Lively's longtime publicist, Mr. Reynolds, Disney, the New York Times, and more. Disney doesn't need any help, I promise. So yes, we're all a part of a massive public relations campaign against Blake Lively. I'm sorry, you are now legally liable and responsible for that, just being in the chat here with me. So I apologize for any exposure you might face in that, but that's what's alleged here. When that article goes up, when the complaint is filed as part of a cease and desist letter with Team Baldoni, it is absolutely crazy to me that they accuse him of leaking out the materials when the New York Times is the one that makes it public and was clearly working with Lively and her associates to get that article done in time for its release on the 21st. That they accuse him of leaking these various things and that everything else is a result of a public relations campaign. I said earlier that part of this document is indicative of the fact that they cannot accept that there's negative press for Blake Lively in any capacity for any real reason. And that rings false, right? That rings hollow. Every human being on earth can have negative publicity. Every human being on earth has somebody with which they are not going to gel and somebody that's going to think negatively about them when they end their interaction and may make a video about it if they have a video platform to do so. And nobody can make friends with everybody on earth. Not me, not Blake Lively, not the Pope, not anyone on this planet has absolutely no criticism placed against them. And so this notion that when she files this, it gets leaked out and negative press happens unrelated to the very, very public New York Times article is crazy. Absolutely crazy. On information and belief, all defendants actively participated in this enhanced retaliation campaign. Defendants counsel threatened numerous lawsuits to sue Ms. Lively and others into oblivion and proceeded to file 4 lawsuits in 3 jurisdictions with fantastical damages of hundreds of millions of dollars each. Now, in all honesty, since they don't have any additional information on Jed Wallace, his lawsuit in Texas is probably why he's added to the defendants list here, so that they can make this sentence. They can say 4 lawsuits instead of 3. They can talk about all of the lawsuits together. On information and belief, defendants counsel has threatened both fact witnesses, neutral commentators, and publications with lawsuits for doing nothing more than speaking out or publicly reporting unfavorable information about the defendants. I can tell you right now, confidentially, that I have not heard from Justin Baldoni's counsel. I've not been threatened with a lawsuit for anything that I have said. And so I am apparently not big enough to be a part of this massive enhanced retaliation campaign. So I'm not getting the big checks to cash on any of this. So sorry to that as well. You're exposed, but I'm not making any money on it. The irony of Mr. Baldoni's response to Ms. Lively speaking out is that his own publicist and co-defendant Jennifer Abel expressed her own dislike for Mr. Baldoni, declaring, "I can't stand him, he's so pompous," and predicted that he would seek to blame others if necessary to protect himself. One thing I would be interested in is whether or not the author of this, the lawyers behind this document, have ever said anything negative about any of their clients in any capacity, and whether or not they've recorded that in email form, because this is ridiculous. Jennifer Abel doesn't like her clients some days. That is a fairly normal response to being a professional operating for someone. And any lawyer in any capacity will tell you that there are some days when a client is not their favorite person in the world. And yet we still love our clients, but they are not always our friends. They're not always asking us to do things that we like to do. They are sometimes pompous. And no, I wouldn't put it in a text message. No, I wouldn't have it in this particular scenario. I wouldn't recommend it for others. But using this in a lawsuit means that you have very few arrows in your quiver. On December 21st and 22nd, 2024, a female cast member who had also complained shared with Ms. Lively that she couldn't believe that they could do this to her. And the fact that this was happening to Ms. Lively was frightening to her. Again, the equivalent of complaint hearsay here, or you're not going to name who this is, and you're just going based on what Ms. Lively says that she was told by this person. Okay, great. We've got the parties. I told you we're not going to go line by line after that fact. We got Jed Wallace here. I think he's still on my search terms. Sorry about that. And then we get into some factual allegations. So the first one is that we have a reference to Ms. Lively's contract. I've said in other videos in this series, there's an open question as to what Blake Lively has signed to work on this movie at various times, because she does abscond during the strikes and doesn't come back even when they're supposed to be filming. She does have or not have a kind of Schrodinger's nudity rider, depending on who you ask and on what complaint you're looking at. And so I wanted to highlight that the contract is referenced here with respect to the intimate scenes. And then I wanted to talk about this slow dance. Without the protections in place, Mr. Baldoni improvised physical intimacy that had not been rehearsed, choreographed, or discussed. For instance, Mr. Baldoni discreetly bit and sucked on Ms. Lively's lower lip during a scene in which he improvised numerous kisses. On another occasion, Mr. Baldoni and Ms. Lively were filming a slow dance scene for a montage scene. Nonetheless, microphones were live to pick up room tone, but not conversations or dialogue to be used in the film. And this is interesting and important because this is a piece of the complaint that we had already seen before in a different context. Let's see if we can get to it in this document. These documents are way too long, folks. This is not how lawsuits are usually written. These are public relations documents, first and foremost, more than legal ones. But we can get to how she described what happened in the slow dance. On another occasion, Mr. Baldoni and Ms. Lively were filming a slow dance scene for a montage in which no sound was recorded. Mr. Baldoni chose to let the camera roll and have them perform the scene, but did not act in character as Ryle. Instead, he spoke to Ms. Lively out of character as himself. At one point, he leaned forward and slowly dragged his lips from her ear and down her neck as he said, "It smells so good." None of this was remotely in character or based on any dialogue in the script, although my mother, who has read the book, has indicated that the "smells so good" line is at least close to, if not identical to, something that is written in the book. And nothing needed to be said because, again, there was no sound. Mr. Baldoni was caressing Mr. Lively, again, Ms. Lively, with his mouth in a way that had nothing to do with their roles. When Ms. Lively later objected to this behavior, Ms. Baldoni's response, Mr. Baldoni's, it's okay, lawyers, was, "I'm not even attracted to you." So that's the original description of events. But again, Brian Freeman and Team Baldoni put out a video of this. And so we will see a wildly changed set of events here. Mr. Baldoni did not provide notice or seek consent for any intimacy in advance. Instead, Mr. Baldoni chose to spontaneously improvise the scene while the cameras were rolling. During the filming, Mr. Baldoni repeatedly leaned in towards Ms. Lively, attempting to kiss her, kissing her forehead, rubbing his face and mouth against her neck, putting his thumb to her mouth and flicking her lower lip, caressing her, and telling her how good she smells. None of this took place while Mr. Baldoni was in character as Ryle, because both the intimacy and dialogue departed from what had been agreed to in the script. Ms. Lively was uncomfortable, there's that word again, and kept leaning away and repeatedly suggesting and then begging that their characters should just talk. So in Baldoni's world, in his allegation, he says that this is an argument of some level with Blake Lively saying her and Ryan Reynolds just talk while they dance and they should talk more. And he says that, well, I think we should stare at each other a little bit more. And then she says something like some sociopaths. She tried to use levity and creative pleas to deflect the unwanted touching, hoping to get through the scene in a way that maintained a professional boundary without antagonizing Mr. Baldoni. This is another area in which I wanted to discuss with you is a potential weakness of the Freeman approach of putting out all the evidence and trying to have this in the court of public opinion is you do allow the other side to comport their storytelling to what is actually out there. They didn't know what that video looked like until you shared it with the public. Now their story can exactly match that. And even more importantly, they can refer to other public persons in their own lawsuit to match up with what we're saying. This is one of the reasons why, and I've heard people ask this when we cover other lawsuits and other trials on these various channels, why witnesses are not allowed to sit in the courtroom to listen to a proceeding is because they can change their stories, and in some respect, humans do this subconsciously, to comport with whatever anybody else has said. So in this particular case, they've seen the video, they know that that's what's happened, and then this continues. In January of 2025, the defendants, through their attorney Brian Friedman, released this video to the media, apparently hoping that the mere act of releasing the footage would mislead the public into believing that it shows nothing abnormal or improper. But the footage by itself corroborates Ms. Lively's description of the scene to the letter. Certainly as it stands now, that is not just Ms. Lively's view. As Mia Schrachter, an independent and experienced intimacy coordinator, noted in response to an inquiry from The Hollywood Reporter, the footage shows Mr. Baldoni trying to kiss her, and they clearly haven't discussed that ahead of time, and she keeps pulling away and clearly doesn't want to do that. Improved intimacy in this scene, presumably that means improvised, intimacy in the scene would not have been flagged for an intimacy coordinator in advance, Ms. Schrachter explained, because in the script they're just slow dancing. There's not any mention of any kind of physical intimacy. As she explained, even though Ms. Lively is not powerless, she still has to keep working with him and keep the peace and play nice, and I can just see her trying to stay lighthearted and in good spirits about it and not upset him or anybody and not waste anybody's time. But of course, she is trapped between a rock and a hard place. I can see her appeasing him and trying to keep a smile on her face. So this paragraph is insanity, right? This is not only speaking to what happened on the video, which you can see for yourself, or what I'm alleging to have happened if I'm Blake Lively. It is bringing in someone else that was speaking to The Hollywood Reporter about this video as, again, 3 steps removed hearsay, responding to what she sees when she's not in the room and not interacting with it on her expertise. So this is essentially kind of expert testimony in your allegations document based on someone who isn't otherwise qualified to speak as an expert on this, and then speaking not only to whether sexual harassment took place, but also the legal standards related to it, right? She's not powerless. She still has to keep working with him and keep the peace, etc. She's talking to the legal parameters of harassment on this score, and it's introduced in this complaint document. So they comported their story to match the video that they didn't know exactly what it looked like before Freeman released it. And then they are using quotes from places like The Hollywood Reporter to essentially bring in what amounts to expert testimony without having it qualified by a court of law in a very unusual way. And I haven't seen this before, I don't think, and I'm not usually looking at lawsuits that are only about things that would have The Hollywood Reporter talking about them. But this is what amounts to a legal party foul. This is not allegations that they can actually make on their own, and this is not someone with personal information other than the video that we all can see ourselves. The court can see the video for itself. Ultimately, the fact that Mr. Baldoni, the director, without advance consent, just went for it, then did it again after she pulled away, is pretty damning, both as an actor and a director, says again this Hollywood Reporter commenter. Ms. Lively complained about inappropriate behavior as early as May 2023, which occurred without an intimacy coordinator present, and which ultimately led to Wayfarer and Sony agreeing with Ms. Lively that the consistent presence of an intimacy coordinator was not only reasonable, but essential. At least as presented by Baldoni, this was never in question. He never had any indication that he didn't want an intimacy coordinator, so it's questionable whether any of this led to Wayfarer and Sony agreeing to it. But it's worth noting, as I said in the first video that talked about this, that one aspect of this story that is problematic for Blake Lively is that the story in January of 2024 is that when I presented these problems to them, they immediately agreed and signed on to the protections, and from there, everything was fine. And to the extent that when you report things through an effective channel of communication and then they respond to that report by fixing everything and everything goes fine, that's not a hostile workplace. You don't have legal liability for every possible thing that can happen, especially ones that you don't know about. And so one of the ways that we look at this from a legal perspective is, do you respond to reports effectively? And at least in January of 2024, when that happens, it sure looks like when they get a report that they can act on, they do what's asked of them. They sign this document, even one I wouldn't have recommended signing in the way that it was drafted. And then the story from there is that everything was fine. So is there a hostile workplace? I don't know, because the one place where we see them actually get a full legal report that they can respond to, they act immediately to fix things. Ms. Lively did not refuse to meet with the film's intimacy coordinator, despite defendants' assertions. She said she did not need to meet with her before production started because there were no intimate scenes in the immediate future, so they could talk once production began. And this is what we've seen throughout these documents. This is a fight on perspective, not on what actually happened. She didn't want to meet with the intimacy coordinator before filming took place, and so Justin Baldoni acted as a telephone representative for certain of these meetings, and she did meet with her in certain other instances. He says that means that she refused to meet with her before production. She says that wasn't a refusal, she just didn't need to. These are the kind of fights that you know of in your own kitchens and living rooms that happen when different people have different perspectives on the same set of events. There's nothing really wrong with what Justin Baldoni had to say. There's nothing really wrong with what Ms. Lively is having to say here, except that she's making a legal accusation about it and the lack of an intimacy coordinator when, at least even as described by Blake Lively here, an intimacy coordinator was available in these things. And that's the dance. I think we're going to skip through most of the rest of this. Throughout filming, Mr. Baldoni and Mr. Heath invaded Ms. Lively's privacy by entering her makeup trailer uninvited while she was undressed, including when she was breastfeeding her infant child. Ms. Lively often had to work while breastfeeding, which she felt comfortable doing so long as she had time and space to cover herself. And then the footnote here, which is interesting, was Ms. Lively was not given proper lactation breaks by Wayfarer during filming, which sometimes stretched into 6 hours without a break. The lack of accommodation for her need to express milk caused her to develop painful mastitis. I apologize, I don't know how to pronounce that. It does sound painful, but it is interesting in inclusion in this document, again, because there's a certain kitchen sink approach to this, right? This is a sexual harassment complaint. This is a complaint about a hostile work environment. And to the extent that you aren't allowing proper lactation time, it could be discrimination on the basis of sex, but you aren't even framing it that way. You're just tossing it in as something bad happening in a footnote, because what you really want to concern yourself with is essentially sexual arousal, which is not a requirement to actually establish a hostile work environment. So it's a strange inclusion in this particular document. We scroll and we scroll and we scroll. It's a 150-page document, folks. Mostly the same as the original complaint here. I think we are scrolling to get to the Wallace stuff. On Information and Belief, the reference team based in Hawaii worked with Mr. Wallace and or at his direction. So now we are talking about the section where they're trying to establish retaliation. And again, I don't know why Jed Wallace is included here entirely. I think it's to reference the lawsuits and to bring in the Texas complaint at the same time and maybe deal with them all in one fell swoop. But where they should be saying exactly what Jed Wallace and his team did, they mostly just describe it the way they did in the original complaint, which is he's around, he's doing stuff, they're talking about him. That's what we got. And like I said, folks, I do apologize for not being able to do a line-by-line with you here, but I wanted to make sure we got an overview done and talked about the major issues here. The two of which are the most significant to me are that they try to bring in other people without referencing them and saying that we're not going to use their names, even though somebody leaked them almost immediately to the Hollywood Reporter. So that was ineffective at minimum to go through all of this rigmarole and make it very difficult to read for everybody else. And two, that they really don't know what Jed Wallace did, and so he is included here as someone that is related to this retaliation campaign that they say happened, but that nobody can actually point to directly. Then we've got another thing that I wanted to highlight, because this is one that I think is likely to be kicked out, but this will ring bells for you if you did watch Johnny Depp versus Amber Heard with us. Brian Freeman made defamatory on-the-record statements about Ms. Lively. It is going to be one of their legal complaints when we look at the counts here as we go a little bit further. And this was, if you remember, the one place where Amber Heard actually won a minor victory against Johnny Depp with respect to what his lawyer had to say about her, again, on those veritable courthouse steps. And so what they have brought into this particular legal document is the notion, much like Depp v. Heard, that there's a shadow campaign against her and we can prove it with comments online, which is absurd and won't hold legal water, and that his lawyer is defaming her, even though he is in the midst of representing his client in an active litigation, which is unlikely to survive a litigation privilege challenge, but it did indeed be heard, so we can't say that with certainty. It's unclear what will happen with that, but I would suggest that it probably won't survive, which leads us to our actual legal causes of action. So, first cause of action, sexual harassment in violation of federal law, aka Title VII of the U.S. federal law. And like we do, we can take a look at what that is. Now, I've brought up for our review the jury instructions in the Ninth Circuit for hostile work environment harassment. Now, the Ninth Circuit is not where we are at. It shouldn't really matter for differences so much because this is a federal law, but the different circuits will have different interpretations of little things. The Ninth Circuit just has the best, most succinct way of putting forth their jury instructions on the internet. And so that's why we're using it here, but I did want to flag for you that this is not the actual jury instruction for what this case would be if it went to trial. The plaintiff seeks damages against the defendant for a sexually hostile work environment while employed by the defendant. In order to establish a sexually hostile work environment, the plaintiff must prove each of the following elements by a preponderance of the evidence. The plaintiff was subjected to sexual advances, requests for sexual conduct, or other verbal or physical conduct of a sexual nature. The conduct was unwelcome. The conduct was sufficiently severe or pervasive to alter the conditions of the plaintiff's employment, and create a sexually abusive or hostile work environment. So it has to be a lot, right? It's not a little. It's not discomfort. It's not uncomfortability. It's not a weirdo that you have to work with. The plaintiff perceived the working environment to be abusive or hostile, and a reasonable person in the plaintiff's circumstances would consider the working environment to be abusive or hostile. So this is what we call the subjective test. They actually had to feel abused. And this is what we call the objective test. A reasonable person would feel abused in the same situation. So one of the defense arguments here is that Blake Lively going out to Saturday Night Live, going out to various interviews or anything else that is suggestive of the fact that she didn't actually think sexual harassment was taking place is a knock on her subjective feeling, right? So that's one of the reasons you tell the story about taking over the movie is why would you do this? Why would you lie about this? Is you have a reason to. You have a motive to actually lie about this, and it's to take over the movie. And we can use as a rationalization for all that you did not actually feel these things because it's enormously useful for you to pretend that you did. So that's what they are trying to do. It's the same kind of shadow campaign as Blake Lively and her team trying to establish the existence of a retaliation. So I don't think it will ultimately hold up, but that's the notions that are behind some of the stuff we see with the movie takeover. And then the objective standard, right? Us looking at this from afar. When we read these stories, is that a hostile work environment? Is that something that actually negatively impacts the ability to work in that space? Some of those stories sound like yes, but the fact, that Justin Baldoni's team has responses to most of those things and different perspectives to see them in does create an open question. So that's the very first thing that we're looking at in this document, and that's what they try to prove here. So we incorporate everything we said above, the previous 115 pages, and then we say she's protected by sex and gender in engaging in the conduct described in the complaint. They discriminated against Ms. Lively in violation of Title VII. The behavior as described in this complaint was severe or pervasive, such that it created a work environment that a reasonable person would perceive and that Ms. Lively did perceive to be hostile, intimidating, offensive, oppressive, and or abusive. So they're trying to get all of those parameters in that one paragraph. The defendants perpetuated this environment by failing to create a workplace in which individuals felt comfortable raising concerns regarding harassing and other inappropriate behavior. Again, look, this sentence says basically, we didn't feel comfortable reporting this properly, so we probably didn't report it properly. The difficulty there is that in creating a retaliation complaint against someone and that they are not going to say actually reported everything in the way that you would expect them to have reported it. They failed to provide an employee handbook, harassment policy, information or training on harassment, discrimination or respectful workplace expectations, etc. All of this is in direct violation of Title VII. They severely impact Ms. Lively's physical, psychological, and emotional well-being. And the defendants are liable because they own and operate the other defendants, etc. Harassing and retaliatory conduct against Ms. Lively continued in various forms throughout 2024 and is continuing, including a coordinated campaign to cast Ms. Lively in a false light, to discredit her in the event that she publicly disclosed her concerns about harassment, and to irreparably damage Ms. Lively's career and future earning capabilities.
As a direct, foreseeable, and proximate result of this unlawful discriminatory conduct, Ms. Lively has suffered and continues to suffer substantial damages, including but not limited to severe emotional distress and pain, humiliation, embarrassment, belittlement, frustration, and mental anguish, and is entitled to punitive damages, right? So she gets anything that she would need to recompense the damages that she actually experienced from being harmed by the harassment. That's what you get claimed to originally. But then she also wants punitive damages, penalties, that this is such a bad act that the law should ask them to spend more because she has all of this anguish, emotional distress, and pain. This is the area in which things like Saturday Night Live appearances would be used in court against her, right? We saw this with things like photos and other aspects of Depp v. Heard, where the lawyers come in and say, okay, yes, you say that you experienced all this and you were crying and you told this to your therapist, but here's a photo the next day where you're smiling and eating ramen or whatever it might be. Defendants at Ends With Us Movie LLC and Wayfarer intentionally violated her rights under Title VII, and as a result are liable for those punitive damages. I don't think there is any question that, as described, even in Blake Lively's description of events here, that these parties that are defendants acted intentionally with respect to the sexual harassment to the extent it existed. You can get them potentially on retaliation if you can prove retaliation actually happened, but the intentionality of the sexual harassment, I don't see. There's perfectly plausible explanations from the Baldoni side of things here that are not otherwise countered in this amended complaint on that score, and that's going to be a problem for them if they sought punitive damages. But realistically, they're just trying to throw everything they possibly can under that cause of action. Next, the second cause of action, retaliation. This is actually the big one. This is what everything is built on, is that the retaliation campaign exists. So here, again, through the Ninth Circuit, which is not fully applicable here, although we are looking at federal law, so they are analyzing the same laws, the plaintiff seeks damages against the defendant for retaliation. The plaintiff has the burden of proving each of the following elements by a preponderance of the evidence. 1, that the plaintiff participated in an activity protected under federal law or opposed an unlawful employment practice. And 2, the employer subjected the plaintiff to an adverse employment action. And 3, that the plaintiff was subjected to that adverse employment action because of their participation in the protected activity or opposition to the unlawful employment practice. A plaintiff is subjected to an adverse employment action because of their participation or opposition if the adverse employment action would not have occurred but for it. If you find that the plaintiff has proved all 3 of these elements, your verdict should be for the plaintiff. And we have a lot of notes on that, including that an employer can violate the anti-retaliation provisions of Title VII in either of 2 ways. If the adverse employment action occurs because of the employee's opposition to conduct made an unlawful employment practice by the subchapter, or 2, if it is in retaliation for the employee's participation in the machinery set up by Title VII to enforce its provisions. So, again, as we look at all these things, is there retaliation here? Depends in large part on whether there's an adverse employment action. An adverse employment action is also defined in these jury instructions, and that's an interesting definition. It's an action that a reasonable employee would have found the action materially adverse, which means it might have dissuaded a reasonable worker from making or supporting a charge of discrimination. Now, adverse employment actions, as described here in the comment, may take many forms. And again, this is Ninth Circuit precedent, so this will vary for the Southern District of New York, including needs to have your union rep statements, putting on administrative leave, deprivation of the ability to take a promotional exam, loss of pay or opportunities. But other conduct may not constitute an adverse employment action, including here, notably in the Ninth Circuit, bad mouthing of the employee. Now, for all of this, if you've ever wondered why your prior employer is unwilling to get on the phone with your prospective future employer and talk about your employment history, this is why. There's a lot of legal liability for saying anything about employees after the fact, and there's a lot of potential lawsuits that prior employers don't want to enter into. Lawyers make the whole world a little bit more tricky to navigate. That's just the truth of the matter. But ultimately, even as described here, if there isn't a report, if there isn't anything that actually speaks of the machinery of Title VII, just going public with grievances is not something that you can say is retaliatory against from a positive PR campaign. You might be able to better do that with a negative PR campaign, but they have to prove that, and they are a couple of steps removed. So there's a lot to discuss on all of this. There is still the requirement that it be severe or pervasive conduct. And other comments I've got here from the California jury instructions, including quotes like, "It suffices to prove that a reasonable person subjected to the discriminatory conduct would find, as the plaintiff did, that the harassment so altered their working conditions as to make it more difficult to do the job." So we're looking at that standard. That's one of the reasons we see that paragraph up there. If an employee other than an agent or supervisor commits the harassment and the employer takes immediate and appropriate corrective action when it becomes or reasonably should become aware of the conduct, for example, when the victim or someone else informs the employer, there simply is no unlawful employment practice that the FEHA governs. And we'll see the complaints brought up in California as part of this complaint. So that's notable, as I said earlier, that part of the story that Blake Lively and her team are going to have a problem with is the January 4th meeting. Looks like Sony and Wayfarer do exactly what they're asked to do. They try to use that as admittance of prior fault, but they don't have a great pathway to establishing that reporting was actually taking place at that point. They really only have conversations with Ange Genetti, which may or may not be in the pipeline of appropriate reporting. Then they try to put that on Wayfarer by saying they didn't have proper reporting mechanisms, which might be right. But it does create a pothole for them in establishing that any reporting was actually done and that any retaliation was taking place as a result of that reporting. So there's a whole lot of holes in Blake Lively's case. There's a whole lot of holes in Justin Baldoni's case. This is a PR fight more than a legal one. That's really your takeaway from all of this, even though we talk a lot about the law here in Hangouts and Headlines. So that's where we are there. We have a few more things to read on these causes of action. Specifically, it is unlawful employment practice for an employer to discriminate against an employee because she is opposed to any practices forbidden under Title VII or because she has filed a complaint against conduct prohibited under Title VII. As Ms. Lively did when she complained to Wayfarer, Mr. Baldoni, and Mr. Heath about harassing and other unlawful conduct based on sex, which occurred throughout the film's production. Ms. Lively engaged in protected activity by complaining to Wayfarer, Mr. Baldoni, and Mr. Heath about harassing conduct based on sex and other unlawful conduct on multiple occasions during the filming and production of the film, which Ms. Lively reasonably believed to be unlawful. After Ms. Lively engaged in such protected activity, defendants subjected Ms. Lively to adverse employment action, including but not limited to by launching a coordinated campaign to cast Ms. Lively in a false light during the publicity and promotion of the film and thereafter. Ms. Lively's protected activity was the motivating reason for and but-for cause of defendant's conduct. This harassing and retaliatory conduct continued in various forms throughout 2024 and on Information and Belief is continuing in order to discredit her in the event that she publicly disclosed her concerns about harassment and other unlawful conduct and to irreparably damage Ms. Lively's career and future earning capabilities. All right, so the first part of this has a hole, which is to say, okay, this is all out in the open, so it can't be, if they are proceeding with a retaliation campaign right now, that it is in order to prevent her from going public with her claims, because the claims are super, super public. You can argue that it's to irreparably damage her career and future earnings capabilities, to really punish her but good for doing any of this, but that's a little bit weaker in this particular case because it's not associated with the initial reporting. As a direct, foreseeable, and proximate result of the unlawful retaliatory actions undertaken by the defendants, she has all this mental anguish and she's entitled to punitive damages, and that they did this intentionally and with malice or reckless indifference. Like I said, this is a stronger claim with respect to the retaliation, provided they can actually prove that it happened, than it is with the sexual harassment, which doesn't appear to be intentional, or certainly with malice or reckless indifference, as it's presented even by Blake Lively herself. Third cause of action, harassment in California. We just looked at those jury instructions. Reiterates everything again, just like Title VII, same deal, but California style. Retaliation under California, same deal, California style. California has a bunch of laws on this. We're in the California Labor Code now. Failure to investigate, prevent, or remedy harassment in violation of California law. And again, they're going to get into a fight on facts as to whether this was properly reported. We have all sorts of questions there. It's not helped by the fact that the Jenny Slate quote in Hollywood Reporter got changed 4 times as to whether reporting actually happened. Like, it's on the exact substance of this particular issue. So there's all sorts of questions as to whether anybody was reporting things. And the paragraphs in this complaint and the original complaint that say, well, Wayfarer wouldn't have responded if we had tried, are not helpful to that particular case. Aiding and abetting harassment and retaliation. This says the defendants that aren't the people, the individuals doing it, were helping them take place. This is Wayfarer and others, as well as the public relations professionals. And again, this is the area where you say, okay, if I'm a public relations person, this is BS. You can't bring me into the fight here for doing what I was hired to do and helping someone's public relations. I'm not trying to cover for sexual harassment. I'm trying to make my client look better. But we saw this earlier. And this is one of those areas where the Hollywood Reporter article about public relations professionals being scared makes sense. Breach of contract. Ms. Lively company Blakel Inc. and defendant entered into a contract for an actor loan out for Blake Lively's performance. At all times relevant to this complaint, there was a unity of interest, so all the defendants are liable. Blakel Inc. has complied. You said we wouldn't be sexually harassed. You're liable for that breach. In the contract writer, you're liable for breach because you promised you wouldn't retaliate. Paragraph 10, we talked about this earlier. Again, we're in the same land as we were in the earlier video, so please do check those out. Intentional infliction of emotional distress. The retaliation campaign was designed to make her emotionally harmed. 11th cause of action, negligent infliction of emotional distress. Even if it wasn't intended to emotionally harm her, it did emotionally harm her and you didn't care that it would. False light, invasion of privacy. You helped folks find out things about Blake Lively that were used against her in a way that was fundamentally incorrect. Sexual harassment in violation of the California Code. And then defamation per se. I told you I would talk about this one. This is where they try to bring Brian Friedman into it. So, as alleged herein, the defendants, including Brian Friedman, published, caused the publication of, participated in the publication of, and or reasonably could have foreseen that their actions would result in the publication of a series of false and defamatory statements of fact about plaintiff, as a reasonably foreseeable and intended result of the conduct of defendants Wayfarer, Baldoni, and Heath and their agents, that's Freeman. Others repeated and amplified these false and defamatory statements. And like I said, this is an area of substantial concern because this is in the midst of a litigation, right? We've got lawsuits flying all over the place. This is counsel to Baldoni saying things. The defamatory meanings of their false and implied statements of fact are apparent from the face of the statements themselves, which include the following. It is shameful that Ms. Lively and her representatives would make such serious and categorically false accusations against Mr. Baldoni, Wayfarer Studios, and its representatives, as yet another desperate attempt to fix her negative reputation which was garnered from her own remarks and actions during the campaign for the film. These claims are completely false, outrageous, and intentionally salacious with an intent to publicly hurt and rehash a narrative in the media. So he's calling her a liar. And this continues for a number of bullet points, but it is in the act of protecting his client and litigating this issue for his client. So normally we would look at this and say, as we talked about earlier, this is full litigation privilege. As California says, when you're in the course of litigation, you can't be sued for things like defamation unless it violates Rule 3.6. We talked about Rule 3.6, which is the things that you can't say with respect to a litigation as put in force in order in the New York case. But in California here, we have these issues with litigation privilege. We see them described in various other places. It says, generally speaking, it's nearly absolute. Even if it were to be illegal, the California Supreme Court has acknowledged that application of the privilege to allegedly unlawful conduct necessarily results in some real injuries to go uncompensated, but acknowledge that this is the price paid for witnesses who are free from intimidation by the possibility of civil liability for what they have to say. To effectuate its vital purposes, the litigation privilege is held to be absolute in nature. So in California, very much protected. We're talking about comments and things that relate to California law for purposes of this discussion. Defamation per se is actually not attached to a specific law here, so it's something like federal defamation or defamation in the Southern District of New York. But suffice it to say, we don't want lawyers to be on the hook for defaming their opposition in litigation because litigation and justice is so important to us. Honestly, this was one area where the Depp v. Heard case, I thought, got it wrong, that was not something that Johnny Depp should have been held monetarily liable for the acts of his agent as his lawyer in this context. But clearly, that was successful for Amber Heard. So I don't blame lawyers for seeking out this particular avenue in presenting their own case. And yet, as a lawyer, even as a non-litigator, I look at it and say, this is a slippery slope to go down if you were to be found liable for the actions of your lawyer in defending you in a litigation like this one. Then we have civil conspiracy. Basically, if you're doing all these bad things, then you are all doing it together. And when you all did it together, you're all liable for each other's acts. And you were conspirators of committing illegal acts against me. And that's it for this legal document. Didn't even look at the timer. So that's 3 hours. My voice is given out. So folks, that's the Hollywood Reporter article. That's the legal document. If you enjoyed this content, please consider supporting the channel through memberships, super chats, Patreon, but only if you're financially able. As my friend Ian just said on Twitter and X, I totally understand if you are not. It is certainly a privilege and not a right to receive any financial support for this channel, but you do help keep the lights on and the family fed. I promise that you do. So please do consider that if you're interested. Otherwise, just subscribing, liking, disliking, telling your friends that these conversations are happening. All of that helps. And if you want right now, if you're live with us and you're not watching on recording, if you have any questions or comments about what I said or about any of the documents that we've looked at before I put this in the podcast links, please let me know right now before we go, and then we will go about our day. Judy, you got this, says thanks for a great breakdown. I appreciate that, Judy, you got this. And I appreciate your dog profile picture, or dog's profile picture, or maybe a dog and a cat. Doing my best here. I can see animals. It's been a long stream already. April Beth says, thank you, Rick. I love doing this stuff. I love having these conversations. I wanted to talk to you all about this. I haven't done a lot of Monday videos because I'm usually rolling into my week, but I wanted to make sure we got this done as soon as we could because I had a lot to talk about. So thank you for being here. Debbie Debacles, I saw someone call it X-Twitter recently. Now I can't call it anything else. X-Twitter is not bad. I don't know why anybody would shorten Twitter, which was an effective brand name, to X, which is a not effective brand name. Try searching for X, or don't. But, hey, I'm not in charge of brand management over there. Cat U says, thank you, Hoeg. Love the informed discussion. I really appreciate it, the well wishes, folks, and I really appreciate everything that you guys do for the channel. Let me know if you have any more comments or questions on any of this before we go. Otherwise, I'm going to leave you to it. I'm going to put up the disclaimer video, and then we're going to go for today. Inigo says, does the change in her description of the dance scene affect her case in any way? Here's the thing. I don't think it'll change the facts on the ground for the actual allegations, but it does suggest, one, what we knew already, which is that all of this is very susceptible to perspective, is very susceptible to how you remember things in the moment. I do think that Freeman putting out all that information is a bold move, but it does allow for the opposition to change things right now before they would have to change them in court in order to comport with what the actual evidence shows. You can imagine a world in which they are trying to prove the case that's originally presented in the original complaint, and that Team Baldoni then puts forward the video and says to the jury, is that what you saw? Because that's not what we saw. And then has that conversation and maybe catches the opposition flat-footed. That's not going to happen here. That's clearly not the way they want to litigate this case. Honestly, I think that's because we're not going to find ourselves in front of a jury at any point. This is going to be settled. But does it change her case in any way? It makes it stronger. It now comports more directly with the physical evidence that we have. I'm just saying, says Just Quick Live, happy almost birthday to Mrs. Hoeg. Yes, Mrs. Hoeg's birthday is very soon. She appreciates, yeah, I can speak English. Thank you for being here with me, folks. She appreciates the well wishes, I'm sure. Happy birthday, Mrs. Hoeg, from all of these folks. Catherine Fraser does note it helps them prevent perjury within the trial. Yes, but perjury, while it plays a dramatic role in Law & Order episodes and very other aspects, as you've seen, especially in a case like this one where perspectives matter so much, is very unlikely to be held against a party, at least in a sanctions type of setting. It can be held against them in terms of impugning testimony, and a jury can say, I'm going to discount everything that person says, what have you. But I really don't think perjury is why they changed it as so much as it comports with what the physical evidence shows. All right, folks. Last call for questions and comments. 1 minute left, I would say. I should get some music. I should have a questions and comments music for this portion. Or I should hum. We could just sing a little bit. Sing your favorite song from Wicked in the chat, in your home. Sing whatever you like. All right, folks. Well, thank you for being here with me today, and thank you for listening to all of this. I hope it was helpful. I hope it was informative. That's really all I want from this process. I did see some stickers come in that I really should grab and make sure I do. Victoria Stavru, thank you so much for the 2 super stickers. I really appreciate it. I really appreciate the support of the channel. I also wanted to mention to folks that maybe didn't know, I am putting virtual legalities, especially ones that are not on a immediate news basis, behind a couple of day membership paywall for folks to get more value out of membership of the channel, to get more value to the patrons of the channel. So if you do like to support the channel through gifting of memberships, please consider doing that. There's going to be more value now and in the future for that on this stream or elsewise. So thank you so much. AVP asks, if the trial isn't public, is it legal to hire a private transcriber? Well, it depends on the court's orders on those particular points. They haven't had any media orders yet because we aren't close enough to the trial. But there will be media regulations as to what can be reported and what accounts are essentially allowed by the court. The court is the king of their own domain. And so we will see when it happens. Chances are no. Chances are you can have a reporter of your own. But we'll see, because this is a trial of major public interest, exactly what the court decides to do. Tide says, I wish StreamYard would let them pull up the image of the super sticker. Yeah, I love to see the stickers. I love to see when a little pair gives me a thumbs up or a number 1. But I don't get to see it in StreamYard. It's sad. For immediate transcripts. I understood the question. Yeah, for timely reporting, as it were. But yeah, we don't know yet. All right, folks. Well, as promised, that is it. Have a good one, and I will catch you on the next episode of whatever it is I decide to do on the Hoeg Law YouTube channel.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.